I declare open this public hearing of the Joint Standing Committee on Treaties. These are public proceedings, although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated as a contempt of Parliament. It's also a contempt to give false or misleading evidence to a committee. In accordance with the committee's resolution of 4 August 2022, this hearing will be recorded and broadcast on the Parliament's website, and transcripts of the proceedings will be published on the Parliament's website. Those here today are advised that filming and recording are permitted during the hearing. I also remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. Transcripts of today's proceedings may not be available in time to meet the deadline for questions on notice. Therefore, could you please keep track of any questions on notice so that you're able to respond in the time required to ensure the committee can meet its reporting deadlines. The committee will now take evidence on the Convention between Australia and Iceland for the elimination of double taxation with respect to taxes on income and the prevention of tax evasion and avoidance, and its protocol. And I welcome representatives from the Treasury, Australian Tax Office and Department of Foreign Affairs and Trade to give evidence today. For the Hansard record, would you please state your full names and the capacities in which you appear before the committee?
Nicholas Dowie, the Assistant Secretary of the Tax Treaties Branch of Treasury.
Rhys Manley, Policy Analysis and Legislation of the Australian Taxation Office.
Kim Ralston, International Law Advising Human Rights and Treaties Section.
Thank you all. Although the committee doesn't require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Mr Wilson, and thank you for the opportunity to appear before the committee today. Before I begin, I'd like to acknowledge the traditional owners of the lands on which we meet and pay my respects to elders past, present and emerging, and any other First Nations people who may be present. On 12 October 2022, Australia and Iceland signed the first tax treaty between our two countries. This is also the first new tax treaty to be delivered as part of the government's plan to add an additional 12 tax treaties to Australia's existing network of 45. It is also the first tax treaty Australia has signed since March 2019, when Australia signed a tax treaty with Israel. We submit that this tax treaty is in our national interest. That's because it will reduce the taxation barriers to trade and investment between Australia and Iceland, which is one of the world's richest countries by per capita GDP. It will reduce the cost of Australians accessing technology from Iceland. It will reduce the cost of supplying Icelandic capital to Australia. It will provide more certainty and reduce compliance costs for taxpayers who earn income in both Australia and Iceland. It will strengthen integrity measures to reduce tax evasion, and it will have a negligible budget impact. The cost to receipts of the new tax treaty is estimated to be negligible over the forward estimates, and it will strengthen our bilateral relationship with Iceland. The treaty reduces withholding tax paid by Australians on income earned in Iceland and by Icelanders on income earned in Australia. The treaty is based on the OECD Model Tax Treaty with certain deviations to protect Australia's interests. For example, the treaty contains Australia's key provisions to preserve Australia's taxing right over the exploration and exploitation of Australia's natural resources, as well as securing reciprocal withholding tax exemptions on dividend and interest payments received by eligible Australian superannuation funds from their investments in Iceland. This is particularly noteworthy as it represents only the third time after Switzerland and Israel that a treaty partner has agreed to exempt income earned by eligible Australian superannuation funds from taxation. This will help to increase the profits earned by Australian superannuation funds in Iceland and help to grow Australians' retirement income. This treaty will also support the government's plan to make multinationals pay their fair share of tax through added integrity measures and mechanisms to facilitate greater cooperation and information sharing between tax authorities to detect and combat tax evasion. The treaty also gives effect to the base erosion and profit shifting recommendations made by the G20 and OECD to ensure that the benefits of the treaty are only granted in appropriate circumstances, reflecting the government's continued commitment to tackling tax avoidance and tax planning practices. Finally, tax treaties also help reduce tax uncertainty and administrative burden for individuals looking to study, live and work overseas, thereby facilitating labour mobility. This tax treaty therefore presents a welcome opportunity to deepen our cultural ties and people-to-people links with Iceland, a country with whom we share many values. I'd also note, just before concluding, that some concerns have been raised with the committee about the constitutional validity of the treaty, particularly in respect to the foreign tax collection rules. We've considered these concerns, and I note the committee will be hearing from Mr Russell directly after our testimony here today, and we've considered the views that Mr Russell has put forward and a review that Australia's treaty model, which references these rules in 7 of our other treaties and has done so for almost 2 decades, are not constitutionally invalid. But we're happy to expand on our reasons for that and indeed our reasoning for why this treaty is in our national interest. Thank you.
Thank you, Mr Dowie. Any other statements?
No.
No. Good. Okay. So we'll get underway with some questions. I've got some, and then the Deputy Chair, and we'll see who happens to be online. Presumably, while this is welcome, because any time double taxation is occurring, it's worth looking at how to reduce double taxation. But presumably, as between ourselves and Iceland, notwithstanding the potential in the relationship and the values we share, there's not actually a large quantum of reciprocal investment or business activity or affected individuals?
I think it's fair to say that the trade and investment relationship between Australia and Iceland is modest, and that this treaty will help present a foundation for those trade and investment links to grow. But you're certainly true. So in terms of the latest information that we have, trades in goods and services between Iceland and Australia was worth $95 million in 2021. And that exports to Iceland totalled $80.6 million and imports amounted to $14.7 million. And certainly current two-way investment levels between Iceland and Australia are modest, but investment levels have been higher in previous years. For example, in 2013, Iceland's investment in Australia was worth significantly higher than what it is now, but we know that certainly since the effect of the pandemic and other things, that those numbers have diminished. We would expect to see those numbers start to recover as we emerge from the pandemic.
Okay. So one of the arguments put forward for these agreements is that they make investment more attractive, and they make investment more attractive because they reduce costs. And those costs are reduced because you're essentially avoiding double taxation that otherwise is occurring. If you are reducing costs and avoiding double taxation, it sort of means that one way or another, the total amount of revenue being derived by both of the countries in the agreement is being reduced. So whatever the amount of taxation that would be gathered collectively by Iceland and Australia with respect to all of the covered activity gets less because some of the double taxation is being reduced. So, just as a matter of mathematical logic, there has to be a reduction in tax revenue as a result. So, do we have some sense as to what the reduction? I mean, the reduction in tax revenue under an agreement like this, depending on where the activity is based, I assume is shared. Like presumably, both sides would see some reduction. One might see a larger reduction. What's the guesstimate on the reduction of revenue for Australia as a result of this agreement?
So we have modelled this, and the cost or receipts of the new tax treaty is estimated to be negligible over the forward estimates.
Well, so if it's negligible to us, then presumably not negligible to Iceland.
We've not modelled what the impact on Iceland's revenue base is.
No, but just as a matter of logic, I mean, we can't put forward the proposition that there's a significant reduction in costs that therefore makes investments made more attractive because the costs are reduced. So in this case, you're saying that the costs of investment into Australia that are being reduced are negligible because we're not actually going to be foregoing any revenue that are contributing to those costs. So that's not going to make Icelandic investment into Australia any more attractive because those costs don't apply. But presumably there's some in Iceland.
So I can certainly speak to the Australian side because what's happening under the treaty is Australia has agreed to reduce its withholding taxes on investment from Iceland. So what that means, for instance, and I'll take you through the numbers about what the reduction looks like. So for example, the reduction in the default dividend withholding tax will go from 30% to up to 15%, which means that for Icelandic investment in Australia, they'll be paying a significantly lower tax rate than what they currently are when the treaty comes into effect. So that means if you're in Iceland thinking about where to invest your capital, thinking about which companies to invest in, which businesses to invest in around the world, currently without the treaty coming into effect in Australia, you will pay a withholding tax of 30% in Australia.
And do we know what that amounts to? Like that, the collection of the amount at the 30% rate, do we know what that amounts to presently? Because that's about to halve.
Look, it is, but it goes to, I think, the point that you were intimating earlier is that the trade and investment flows currently between Australia and Iceland are modest.
Yeah.
And as a consequence of that modest base, that comes back to why we think the impact of this will be negligible.
Yeah, but what we would say, if just to pick a number, if the amount of withholding tax currently being paid under that rate, just to pick a silly number, was $1,000 a year, it's about to become $500 a year.
Assuming that everything else is constant and all those other things and there aren't any second round effects, so that would, yes, be true.
Yeah, and the reason we say it's negligible is because we're just not collecting much of that at the moment. It wouldn't be negligible if there was some sort of substantial investment, and I guess what we're hoping is that that's what might follow.
Yes, that's right. So our view is the economic relationship is currently modest, which limits the withholding tax that is currently being collected. But we expect the treaty to create a more favourable investment environment, which could help to increase investment flows in the future. And certainly, if you're an agnostic capital investor from Iceland, thinking about where are the opportunities around the world for you to actually maximise your profit as a result of this tax treaty, the investment calculus now means Australia is a much more attractive proposition than what it was prior to the tax treaty being signed.
Yes, no, that makes sense. We have 45 of these agreements. It seems like the world is crying out for a multilateral instrument that would allow Australia and other countries where they can negotiate with another country that this sort of thing should come into place, that it could be done by some sort of multilateral instrument that you accede to or you sign other people up to, rather than having to go and do bilateral after bilateral after bilateral. Has that ever been something that's been contemplated?
So there have been moved by the OECDs and others to help facilitate the bilateral process by having a model that people can sign up to. Countries haven't moved away from that in terms of having a multilateral deal in terms of the withholding tax rates that are charged on various levels of investment. And that reflects the fact that everyone comes to the table with very different taxation rates and very different taxation arrangements about what they seek to tax and what they don't seek to tax. There has been multilateral moves to certainly put in place standard rules around tax evasion. But in terms of the other things that a tax treaty covers, like what would the rate of the withholding tax be, which countries have the right to tax particular parts of income, that remains a very contested issue, and certainly there's not a degree of multilateral consensus necessarily on who gets to tax which particular forms of income and at which taxation rate should be levied, and that's why it's been a consensus not just with Australia but most other countries to do these things bilaterally as a way of trying to actually work through the various different starting points that individual countries have to try and reach an acceptable compromise. Okay.
So look, I will invite you to say a bit more about the matter that Mr. Russell has raised, the sort of the constitutionality of the foreign tax collection part. I mean, essentially, his argument is that it's not done under the taxation powers. It's the external affairs powers allows Australia to enter into the treaty that creates the obligation or the commitment to undertake the foreign tax collection. But in his argument, that collection amounts to a sort of an appropriation of property that isn't done in the right way. And he refers to that phrase "just means." Presumably there's no there's no opportunity for a person subject to that collection to contest it and these various other things. So yes, I think it'd be useful for the committee if you're happy to speak to your view of the constitutionality and other legal issues around that point.
Certainly. So we did consider the issues raised as part of Mr. Russell's submission, and I'll talk through where we've got to and the reason for our thinking. And we did consider them, and we don't think that the issues that Mr. Russell have raised would mean that this treaty is constitutionally invalid. So the issues that Mr. Russell's raised, as you've noted, go to the assistance in the collection of taxes article, which effectively means that under the treaty, it's Article 25 in this particular treaty, that countries are able to collect debts on behalf of each other.
So it's essentially when there will be some entity or individual who happens to be in our jurisdiction, we would be collecting what Iceland regards as being taxation due to it.
That's right, and I'll talk about what that means. So this is, and I think there's a principle, there's a well-established principle here in international tax treaties that is an appropriate part of what tax treaties should look like. It's been part of the OECD Model Tax Convention for over 2 decades, and our tax treaty is based on that. It's contained in 7 of Australia's tax treaties, so if this treaty were, not including this one, so if you include Iceland, 8 of the 46 have this particular clause in it. We've signed up to the OECD's Multilateral Convention on Mutual Administrative Assistance, which also generally provides for assistance in the collection of taxes. So the concept of assistance in collection of taxes is certainly not new.
Sorry, not to interrupt you, but just out of interest, I mean, you say that this will be the 8th, so there are 7. Is it true that we commonly in any given year collect tax due to some or all of those other 7 nations?
So I don't have that exact information in front of me about what the number of cases are where this clause is enlivened or the sum of revenue that is there.
But are you able to say that it has occurred? So it's not like this is not a completely theoretical thing. There would be some instances where we have essentially undertaken foreign tax collection.
Yeah.
Yes, it does occur. We can take on notice of how often
Sure.
it occurs.
Yeah. But yes, your point is right. It's not a theoretical abstract issue. It is used.
And I'm sorry, I apologise again for interrupting you, but has anyone actually taken legal action along the lines of Mr. Russell?
We're not aware of anyone challenging this particular clause and the provisions behind it on the basis of the arguments laid out by Mr. Russell.
Yeah, okay. Sorry, I didn't mean to interrupt you.
That's right. So, as our view is that relevant laws are constitutionally valid, as Mr. Russell noted in his submission to the committee, the foreign tax collection rules are validly authorised by the external affairs power of the Constitution. And we note that I think it's important to talk about the way in which we've implemented this, which I think goes to our thinking about why we think this is not an issue. So we note that the assistance in collection scheme has been implemented in a way that equates the foreign revenue liability to a foreign judgment or an administrative order. So that means the Commissioner of Taxation registers the foreign tax liability, which would convert it to a debt owed to the Commonwealth that can then be recovered by the Commissioner employing their normal tax collection and recovery powers. As such, Australia is not, in this way, not imposing the taxes of a foreign country, which in our view overcomes some of the impediments that Mr. Russell has suggested could affect the constitutional validity of the treaty. We'd also note that the scheme has been implemented in a similar fashion to the child support scheme, which allows the child support registrar to use their powers to collect overseas maintenance liabilities, and which we're not aware of that being challenged on constitutional grounds either. And just to talk a little bit more in terms of how we've actually implemented this, or how we have for other treaties, given that this treaty is still going through its implementation process. Our view is the foreign tax collection rules in Division 263 of the Income Tax Assessment Act properly give effect to the requirements of the Assistance in Collection article of the treaty and other similar articles in Australia's bilateral tax treaties and the Multilateral Convention on Mutual Administrative Assistance in Tax Matters. So Division 263 provides that certain requirements must be met and the Commissioner needs to be satisfied that they are met before registering a foreign revenue claim. For example, the definition of foreign revenue claim in section 263.10 requires that it is made in accordance with an agreement, and section 263.15 provides 5 criteria for a foreign revenue claim to be valid. Most relevantly, subsection B requires that the claim must be consistent with the provisions of the relevant treaty, and section 263-25 provides that the Commissioner be satisfied that the claim has been made in accordance with the requirements in 263.15 before registering it. These requirements in Division 263 provide the mechanism for ensuring the claim is validly made in accordance with the relevant treaty or multilateral agreement. And as you've mentioned, the assistance in collection of taxes articles is found of 7 of Australia's other tax treaties. The first one was signed in 2006, so it's been a really long-standing bipartisan feature of the way in which Australia has gone about negotiating tax treaties. It's consistent with the OECD policy and international practice, and we've also signed up to the OECD Multilateral Convention on Mutual Administrative Assistance, which generally provides for assistance in the collection of taxes. And as I said before, to our knowledge, no taxpayers have sought to challenge the constitutional validity of the laws on the basis of the arguments that Mr Russell has put forward.
And if I could also add, the Treasury has discussed this matter with the ATO as well, and we've also considered the question of Mr Russell's arguments under the Constitution, and we are of the same view as the Treasury.
And in reaching that view, in the ATO or the Treasury, or has specific, legal advice or analysis been sought or undertaken at any point?
Yes.
Okay. All right. Well, look, I think that's interesting. Obviously, we're going to hear from Mr. Russell. The last thing I'd invite you just to say a bit more about, because it interested me in your opening remarks, is the way in which this agreement is one of only 3 that has some special application with respect to the treatment of superannuation. So perhaps if you just say a bit more, and then I'll hand over to the Deputy Chair.
Sure. So it's certainly been, as the Australian superannuation industry has grown, the Australian superannuation funds are looking across the world for avenues to invest members' funds. And one of the things that we've been seeking as part of our tax treaty negotiations is to give is to exempt Australian superannuation funds from the application of withholding taxes of investments that they make overseas, as a way of trying to encourage a greater two-way trade and investment, but particularly giving Australian superannuation funds more opportunities and more investment targets to invest in a way that maximises the benefits for their members and Australians' retirement income. So the first one we did this was in Switzerland, I think in 2013. We followed up with Israel in 2019, and now with Iceland in the treaty we signed in 2022. This has been a relatively new feature of Australia's tax treaty system, given we started in 1946, and that reflects the fact that the superannuation industries are now quite strong and looking for investment opportunities elsewhere. It also reflects direct feedback we've received from the superannuation funds that this is something they would like to see in our tax treaty network. So we've been trying to negotiate that. Our success in negotiating that obviously depends on the willingness of the other treaty party to accept that. The arguments that we put forward to our treaty partners is we think it's a genuine win-win. We think it's a benefit to Australians through Australians' retirement income. We also think it's a benefit to the other treaty partner in that whilst they are reducing the level of tax that they are levying on this, we think that the second round impact of that will be positive. That is, that by reducing taxes, you make investment in the treaty partners' countries significantly more attractive, and given that the Australian superannuation industry is worth $3.3 trillion, allowing them more incentive to get a bigger slice of that market, we think is in their interest. So that's an argument that we've been putting. It does recognise, though, too, that our superannuation system is quite different from many of the superannuation systems of the countries with which we are negotiating. So often it can take quite a bit of time to explain that and to make our case. But certainly this is the position that we do take in our negotiations with other countries, based on very strong feedback we've received from the Australian superannuation industry and others. So we think we're very pleased with this treaty in Iceland because we've been able to secure this, and the more treaties in which we're able to secure it, the stronger a negotiating precedent it becomes for future treaties.
Do we have a process of going back, and this is one of the problems obviously when you have lots and lots of bilateral agreements, this superannuation arrangement seems to me very sensible. Obviously, we would love it if it could have been incorporated in all of the other 43 or however many. Is it ever the case that we revisit these agreements and sort of seek to update them?
Yes, it is. So many of the treaties we've had have been renegotiated a number of times. So, for instance, our very first treaty was the UK, which I think we negotiated in 1946 and signed in 1947. We've renegotiated that a number of times, most recently in 2003. And there's been many treaties in our treaty network that we've updated when it's become apparent that what was initially negotiated made sense at that point in time, but it's no longer fit for purpose. So often our treaties are renegotiated, and that's a matter for government to determine when it's settling the treaty program in terms of who should be on it. Should it be a new treaty or should it be renegotiating with an existing treaty partner?
Yeah, presumably if you identified all of the nations with whom we have such an agreement where there is significant investment opportunities and investment as it currently stands, they would be the priority ones if you wanted to take something like the superannuation measure and make it a feature of those agreements. But I'll go to the Deputy Chair and then perhaps to some other committee members.
Thank you. Thanks, Chair. How many double taxation agreements does Australia intend to conclude?
So on the 16th of November 2022, the Assistant Minister for Competition, Charities and the Treasury, Dr Andrew Lee, announced that the government has committed to an expanded tax treaty program that would see Australia negotiate an additional 12 treaties. So we currently, not including Iceland, we currently have 45. The plan is to sign and implement an additional 12, which includes Iceland, which would take the total number of treaties in our treaty network to 57.
Okay, and are we negotiating any other double taxation agreements at the moment?
Yes, we are. So we're currently in the process of negotiating with Portugal, Slovenia, Greece, Lithuania and Estonia, and we've also had some negotiations with Luxembourg too. So we have an active program of negotiations ahead of us, and all of those negotiations are at various stages of maturity, and we're also planning to commence negotiations with Latvia and Colombia shortly.
On what basis are these agreements made? So you've named some other countries that we're negotiating with. Are they a trading partner? Are they future trading partners? What are these decisions made on?
So the composition of our treaty program is a matter for government, but often the things that are looked at to help inform that decision is some of the things that you've suggested: the strength of the trading relationship, strength of investment flows. Other bilateral factors are considered as well in terms of how we should deliver these things, because it's often, we can sometimes underestimate our importance on the world stage, and recognising that Australia is a G20 economy, and there's certainly a lot of symbolic value in offering tax treaties to other countries who wish to do more business with Australia. So there's a range of factors, whether it's trade flows, investment flows,
Friendship.
I'm sorry?
Friendship.
Indeed, yeah. A range of things that government considers in terms of allocating that program.
Okay. I'm fine, Chair.
All right, thank you, Deputy Chair. Mr Pike or Mr Burnell, any questions? No?
No questions from me, thanks, Chair.
No. All right. Well, look, I'll just finish with one. I mean, I'm always interested in looking at the part of agreements that cover dispute resolution. So I'm just interested about, to the extent that we've needed those mechanisms in relation to any of the 45 treaties that we're already part of that cover double taxation?
So from time to time, incidences emerge in which either various taxpayers or various countries believe that one country is not acting in accordance with the treaty. And generally how that comes about is because a country levies a tax, and one of the taxpayers under the treaty says, well, you traded off the right for that. So a tax treaty at its core, what it does is it allocates taxing rights between countries to avoid both double non-taxation and double taxation. So generally there will be an occasion where someone may say that an aspect of the tax authority's behaviour or a government policy that's been put in place to raise revenue is inconsistent with what the tax treaty has said. And that can then take a range of forms between, often if it's a directed taxpayer who raises it first with their home government to raise with the other government in terms of how it might be resolved. And that's when the mutual agreement procedures, which in this case is Article 23 of the treaty, are kicked off. And generally it's about what we call the competent authority, which is a technical term, which in our case is the Australian Taxation Office, which is responsible for administering the treaty, has a conversation with the other competent authority to work through the issue that's been raised.
Okay, so so this does happen. It's not uncommon. It's been the case in the past. It presumably be the case in the future. And you're suggesting that it's often initiated by an individual or an entity that's covered, and that sort of believes that either something isn't quite right, and they'll ask their own nation to investigate it or take it up.
That's right. So I wouldn't say that disagreements are common, but I'd also say though that they're not rare. I mean, there has been certainly a history of them. That's certainly true, and you're absolutely right. It's generally raised by the person who pays the tax, who has the most incentive to resolve it. They then raise it with their home government, and then it's taken up in a government-to-government conversation to resolve those issues.
And do the dispute resolution mechanisms work? I mean, do we generally find that, as between ourselves and another government in that situation, that we're able to get to something that we think is a fair solution to the issue?
Well, we certainly have conversations about it. I think it varies in terms of that. Some of the clauses rely on countries working it together in a bilateral dialogue. Others have a clause that goes to arbitration. So in many cases, though, the dialogue we have between governments is critical in resolving it recently.
Yes. You've basically covered everything. It's usually through the consultation process.
And so this one, I mean, this agreement will have an arbitration feature within the mechanism, but some don't.
We certainly under Article 23, this one is under Article 23.5, any unresolved issues arising from the case shall be submitted to arbitration if the person so requests it in writing.
And what's the arbitration body? Does that need to be created specifically, or is there some pre-existing tribunal or something that gets used for these things?
No, we would need to create it. In fact, it's spelt out under page 26 of the treaty in Article 23, paragraph 5, where it says the competent authorities of the contracting states shall by mutual agreement settle the mode of applications of this paragraph, which basically means that in the event that there is a dispute, in the event that it does need to go to arbitration, Australia and Iceland would settle the terms of what that would look like.
All right. It might be interesting for the committee if you could just take on notice, just give us perhaps an example or two of how that's happened in the past. So presumably that same thing has occurred where a dispute arises, that there's not a pre-existing tribunal or there's not a pre-existing mechanism. They then agree on a mechanism by which it'll be resolved where they can't resolve it themselves. I assume that that's sort of what happens. You first of all have a intergovernmental conversation. If you can work it out, that's good. If you can't, you have to agree on some sort of arbitration mechanism. A panel is appointed. They consider the matter, they provide a determination, and the two countries agree, something like that.
Yeah. So we can certainly give you some examples of how arbitration has worked in the past under some of our treaties, noting that all of our treaties are slightly different, so they will work slightly differently, but we can certainly draw on some practical examples of where some of the most recent ones have operated.
Sure. Thank you. All right. Well, thank you for your attendance here today. If you've been asked to provide any additional information, which I've just done, obviously please forward it to the Secretary within 7 working days. As I said in my opening remarks, it's always the witness's responsibility to meet the deadline in a timely manner. You all know that. You will be sent a copy of the transcript of your evidence when it becomes available, and then have an opportunity to request corrections to the transcription errors if there are any. But thank you all for being here again this morning.
Thank you.
Thank you.
So this hearing will suspend temporarily until we straighten out the next person. All right, I will resume this public hearing of the Joint Standing Committee on Treaties, and I welcome Mr Tim Russell to give evidence today. For the Hansard record, Mr Russell, would you please state your full name and the capacity in which you appear before the committee?
My full name is Timothy David Russell, and I am a barrister in private practice.
Thank you. While the committee doesn't require you to give evidence under oath, I should advise you hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence you give today will be recorded by Hansard and attracts parliamentary privilege. Mr Russell, I invite you to make an opening statement, and then we'll have a bit of a discussion and some questions.
Okay, thank you. My opening statement, I'll try and keep it as simple as possible. It is in where Australia, the executive government of Australia enters into a double tax treaty with a foreign government. That is implemented into Australian law by the Parliament, and in so doing the Parliament conforms with the powers set out for it within the Constitution. And in 99.9% of instances involving double tax treaties, it's very clear that the authorisation for Parliament to implement the treaty into domestic law arises under the taxation power, which is paragraph 2 of section 51. However, as treaty practice has developed, particularly over the last 20 years, treaties are now trying to do more things than historically they have been doing for the last 100 years. One of those is what the OECD calls Article 27, which in the proposed Iceland Treaty is Article 25. And that requires the two member states to act as agent for each other on behalf of each other in collecting taxes from persons who are resident within the jurisdiction but who owe tax to the other jurisdiction. Now, my argument to Treasury last year was when Australia first agreed to do this back in 2006 and implemented a special division in the Taxation Administration Act, which is Division 263 sub A. Was there any constitutional consideration given to this specific article? Because it doesn't work in the same way other articles work. I put down in my paper to Treasury, and it is just my opinion, but it's an opinion I thought worth contradicting or verifying with the Attorney General's office. I put down the opinion that this particular article cannot rely on the taxation power for Parliament to pass it, because it doesn't relate to what the High Court has held constitutionally constitutes taxation. With that said, it is perfectly within Parliament's power to implement the treaty provision, because there's another head of power it can rely on, which is the external affairs power in paragraph 29 of section 51. However, that comes with a catch. If you fall within the external affairs power and not the taxation power, that power is subject to paragraph 31 of section 51, which requires compensation or property to be acquired on just terms. And this provision does not acquire property on just terms. It just takes it, which would be fine if it was a tax. The taxation power is an exception to the just terms requirement. But the external affairs power does not carry that, or does not benefit from that exception. So that was really my argument. The Treasury should have taken this argument to the Attorney General's Department, debated its merits and published a statement as to its view on its correctness. But if it turns out to be a matter they've never considered, and Australia is now going through this exercise of entering into mutual promises with other governments and it later transpires that we lack the authority to do so, I perceive that as very embarrassing for the government of the day and for all governments that were part of the process. The 2006 provisions having been introduced by the Howard government.
Okay. Well, thank you, and thank you for your submission too, which was substantial, but actually also as an expression of legal opinion, well framed for the understanding of those of us on the committee, not necessarily with the same kind of legal experience or expertise that you have. We've had the department here this morning. I'm not sure whether you tuned in and heard that part of the evidence, but you'll be able to see the transcription when it becomes available, where the committee has put the points that you've raised to representatives of the Treasury and the Australian Taxation Office, and their view is that the approach taken is constitutional, and we've been advised that the view is based on specific legal advice. Obviously, despite I guess I should just confirm, you've directly approached, is it both the Treasury and the Attorney General's Department, or the ATO and the Attorney General's Department?
I approached Treasury and through people I know professionally at the AGS, the Australian Government Solicitor. I asked if I could be connected with the relevant person from the Attorney General's Department. That inquiry was made, and I was told that it wasn't within their gift to speak to me in my private capacity unless this issue was put before them by Treasury, by another arm of the government.
Okay. Well, as I've just said, we've been advised that specific legal advice or a legal opinion on the point has been formed. Obviously, it hasn't been shared with you. I guess we'll just pick up a few of the things you've said. I mean, that this committee, as you understand, we're not in a position to be the arbiters of legal opinion or a dispute or a suggested dispute about what the law is. One of the things that was said this morning was that the effect of the treaty, or the view put of the effect of the treaty, is that it actually creates a debt to the Commonwealth. So, and I'm not sure, everything I say is going to be at risk of not being legally helpful, but the suggestion was that the collection occurred on the basis of what was regarded as actually a debt to the Commonwealth, even though it affected the collection of tax for the purpose of remitting it to another country. I mean, is there a construction of the way that the money is collected that could, through the agreement, then fall within what would be an acceptable exercise of the taxation power, in your view?
No, I don't believe so. I don't believe it would fall within the express grant of taxation power or the incidental grant, and I put that in my submission.
And if then for the appropriation that occurs, it requires it to be done on the basis of just terms, what I think you say in your submission that there's no opportunity for a person to contest the appropriation. These are the kinds of things that would otherwise constitute just terms.
Yes, there is no opportunity for just terms, and it's sort of, and I think this is where the trouble may have arisen historically, it's sort of counterintuitive. If you're taking money off someone, it's counterintuitive to think of giving them just terms, because that would involve giving the money back. However, I apprehend that is the precise effect of the way in which Division 263A has been authorised, that it is validly authorised under the external affairs power, but it lacks authorisation under the taxation power. And the effect of that is that and there were High Court cases, Newcrest Mining, which was a 1994 case, which held that Parliament can legislate to implement treaties with other countries. In this case, it was an environmental treaty that took away mining licences at Kakadu. But boldly, the legislators tried to do that without compensation for the mining licences being taken away. And the High Court said, no, you can't do that. It's the external affairs power. Everything that is done within it has to be subordinate to the requirement of just terms.
Okay. We were pointed to the fact that there are some other legislative arrangements that allow or provide for, how am I going to put this? For helping to ensure that people are making proper contribution to the welfare of children. You know, sort of family tax and family support benefits that also operate internationally. That we have some arrangements of that kind that allow people who may no longer be in the Australian jurisdiction to be sort of held liable to make contributions as parents. Have you considered those arrangements as to whether they sort of fall in the same constitutional difficult space?
I have not, no, and it's an interesting point. I mean, it might be that an arrangement of that nature finds authorisation in some other provision of the Constitution as well, but no, I haven't considered that at all.
Okay. Deputy Chair?
No, I just want to thank you, Mr Russell, for taking the time to submit your submission and your very keen interest in this. We do appreciate you taking the time to speak with us this morning.
And look, I don't think, unless I'm not seeing other committee members wanting to ask questions, I mean, I share what the Deputy Chair said, and particularly the way that you presented it is relatively easy for us to grasp the point that you're making. I sort of would observe that the committee is, in this sense, or in this format, almost kind of an intermediary venue between the legal expertise that you have and the legal position and opinions that the relevant departments have, and it would really make the most sense if you and they were able to have a conversation about these things more directly than through us. I'm not sure whether that can be facilitated. You've presented a legal opinion. I mean, ultimately, this is something that would be tested in a court. So it's not out of the question that someone will be, or either a company or an individual will be subject to the collection of foreign tax under one of these arrangements, and they'll go and test the constitutionality in a court. But as far as you would know if that had been the case, I'm sure, and we haven't been advised that that's been the case.
This argument hasn't been tested before.
Okay, all right. Well, again, thank you for your attendance here today and for your submission. We haven't asked you to provide any additional information, so there's no requirement for you to provide anything further to the committee. You will be sent a copy of the transcript of your evidence when it becomes available, and we'll have an opportunity to request corrections to transcription errors. But otherwise, again, thank you for both the submission and your time with the committee today.
Thank you, Mr Chairman.
All right, I will suspend this hearing, committee members, until 10:40 a.m. Okay, the committee will resume this public hearing and now take evidence on the Convention on the Protection of Underwater Cultural Heritage. I welcome representatives from the Department of Climate Change, Energy, the Environment and Water, and the Department of Foreign Affairs and Trade to give evidence today. For the Hansard record, would you please state your full names and the capacities in which you appear before the committee?
I'm Leanne Burrows. I'm the Director of Cultural Heritage in the Department of Climate Change, Energy, the Environment and Water.
Excellent.
And my name's Dr. Andrew Viduka. I'm the Assistant Director, Underwater Cultural Heritage in the Department of Climate Change, Energy, the Environment and Water.
Kim Ralston, Director, International Law, Human Rights, Advising and Treaties Section.
Thank you. Although the committee doesn't require you to give evidence under oath, I should advise you that this hearing is a legal proceeding for Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement or give us some opening remarks before we proceed to discussion and questions.
Good morning, and thank you for asking me to introduce the Convention, setting it within the bigger picture and highlighting how the Convention helps solve these problems. Due to the development of the self-contained underwater breathing apparatus SCUBA around 1943, post-World War II there was a boom in recreational scuba diving activity. Stemming from this, many new discoveries were made of shipwrecks, sunken planes, submerged settlements and sunken cities around the world. Associated with these new archaeological discoveries was the unregulated recovery of artefacts from sites, sometimes literally involving the destruction of the site in the process. Looting of sites has the impact of not only removing artefacts and damaging the site, but of disturbing or destroying the associated context of objects between each other. Looting of sites is akin to removing chapters from our history, with the loss never to be replaced and the story never to be told. Around the 1960s, countries began to introduce legislation to protect underwater cultural heritage sites from the destruction of heritage. In Australia, the first such legislation was introduced in Western Australia in 1964 to protect old Dutch shipwrecks found off the coast of WA from looting. These sites, Vogeldracht, Batavia, Zeewick and Zuidorp, were later gifted to the Commonwealth of Australia by the Kingdom of the Netherlands. To ensure protection of the old Dutch shipwrecks, now owned by Australia, the Australian government introduced the Historic Shipwrecks Act in 1976, which has since 1983 been collaboratively administered with the states and the Northern Territory. In 1994, Australia ratified the United Nations Convention on the Law of the Sea, UNCLOS. UNCLOS obliges states to cooperate for the purpose of protecting objects of an archaeological and historical character found at sea. However, UNCLOS does not set out a comprehensive regime for the protection of underwater cultural heritage and therefore expressly allows for a more specific international agreement. Globally, looting of sites has continued and since the 2000s has reached industrial levels in some countries. For example, tens, if not hundreds of World War II era shipwrecks, including sovereign vessels, have in the South China Sea been looted and removed for scrap metal over the last decade or so. In 2017, it was reported that ships in this area, which contained the remains of approximately 4,500 Australian, British, American, Dutch and Japanese servicemen, have been impacted. This illegal activity continues today. As a response to the ongoing global destruction and looting of underwater cultural heritage, the UNESCO Convention on the Protection of the Underwater Cultural Heritage was drafted consistent with UNCLOS. In 2010, the Commonwealth of Australia, the States and the Northern Territory signed the Australian Underwater Cultural Heritage Intergovernmental Agreement to confirm our jurisdictional arrangements and to agree to undertake any necessary legislative changes to enable Australia's consideration of ratification of the 2001 Convention. In 2018, the Australian Government introduced the Underwater Cultural Heritage Act, repealing the 1976 Historic Shipwrecks Act. The new Act broadly aligns with the Convention. But how does the Convention help solve the problem? Underwater cultural heritage is a finite archaeological resource that is increasingly accessible and impacted by human activities. The Convention sets minimum standards for the protection of such heritage with a view to preventing it from being looted or destroyed. The Convention's standards are comparable to that granted by other UNESCO conventions or national legislation on cultural heritage on land, but yet specific to archaeological sites underwater. The Convention is focused on management, on collaboration, communication, consultation with countries with shared heritage interests in sites, as well as capacity building within the region to improve standards. The 2001 Convention sets out basic principles for protecting underwater cultural heritage, contains provisions for an international cooperation scheme, provides practical guidelines for dealing with such heritage, and ratification will prevent the commercial exploitation and scattering of underwater cultural heritage artefact assemblages from sites. facilitate the full alignment of domestic laws with international standards governing the protection of underwater cultural heritage, provide a legal basis to regulate activities of foreigners and foreign flag vessels directed at underwater cultural heritage beyond the territorial sea, help the tourism industry, such as dive charter tourism, by encouraging responsible access. Through increased cooperation with state parties to the Convention, Australian universities will benefit and be more competitively positioned to attract international students and deliver world-leading best practice education. And critically, ratification of the Convention will enable the implementation of the Convention's Annex rules, giving a basis for the development of uniform national standards that clearly articulate the responsibilities of individuals, non-government organisations and businesses when undertaking activities in the marine environment. Internationally, ratification of the Convention will enable Australia to join and participate in the global community's response to the looting and destruction of underwater cultural heritage. It will enable Australia to assist in stopping the trafficking of stolen underwater cultural heritage artefacts or their movement through Australia. It will enable effective international cooperation on the subject matter of underwater cultural heritage, and it will position Australia to be well placed within the Indo-Pacific region to show leadership, exchange knowledge and capacity building training in maritime archaeology, maritime archaeological conservation of sites and artefacts, and underwater cultural heritage management. Thank you.
Thank you. Ms Burrows?
I don't have anything to add.
Okay. Well, thank you. And it is momentous that we get to this point now where the prospect of ratifying the convention that was entered into, that came into being in 2001, and that was a very useful overview of the steps. I say as a Western Australian, there is some pride that first by amendment to, I think, the Museum Act initially, and then the dedicated shipwreck piece of legislation, that we were ahead of the curve. But we've seen it eventually become a matter of national legislation and then our participation in these different international agreements. The Underwater Cultural Heritage Act of 2018, in a sense, not preempts the ratification, but I guess puts us in a position where, as I understand it, Australia is confident that we comply with the convention that we're about to ratify. Sometimes Australia signs and then ratifies an agreement and has sort of implementation obligations as a result. So is it right as a starting point to say that new piece of law in 2018 gives us confidence that at the point which we ratify the convention, that Australia is in compliance with its requirements?
The 2018 Act broadly aligned Australia with it. We do require enabling provisions to be put in, so there is drafting that's required here for that, and the introduction of new legislation to enable that component. But it broadly aligns us along the definition of underwater cultural heritage, and most of the other elements are encapsulated within. We do have to pick up some of the obligations that we take on as a state party within the convention. We have to make the convention an object of the Act. The convention has to be something the Minister has to consider when making decisions. So there's a number of changes that need to be made into the Act, but broadly we are very closely aligned.
Okay. And obviously in Australia's point of view, going from the kind of continental landmass outward, there's responsibilities that fall to the states and territories in the sort of near waters, and then for the Commonwealth out to the extent of our EEZ, and then for the Commonwealth to the extent that we cooperate with other nations in relation to heritage that is either in their territorial waters or in some cases, I assume, in the realm of the high seas. We note that one of the submissions we've had, which is from Western Australia, states that beyond ratification, state jurisdictions will require some time to review and amend their own legislation. So presumably that's the kind of further work that you're talking about.
There will be a packet of further work. So just to come back on the jurisdiction, because the Historic Shipwrecks Act 1976 preceded the offshore constitutional settlement, in 1978, when that settlement was being formed, everyone agreed that the Australian government would retain lead for the management of shipwrecks to the coastline. Oh. So shipwrecks are managed under Commonwealth legislation from the coastline out to 200 nautical miles.
So even in what would otherwise be regarded as state
That's
waters.
right. And that was all decided back at the Offshore Constitutional Settlement. So, and then what is led by in the states is the protection of other underwater cultural heritage and submerged aircraft. That's what the states lead in state waters for off the shore in the state coastal waters. So they will take a period of time, should Australia ratify, to then bring their legislation for that other underwater cultural heritage and submerged aircraft, so that that's similar to the Australian legislation, and that's creating that uniform national administrative environment so everyone has a consistent approach to things.
So in terms of the actual, the sort of impact and potency of these arrangements, I guess I'd start by inviting you to reflect on what we've done in our EEZ. At some point, when scuba equipment became prevalent, there was this opportunity for people, a much greater opportunity for people to sort of discover things. And it would seem that in the 60s and 70s, that kind of finders keepers mentality prevailed, and as a result, things that were discovered were not disclosed, items were removed, sites were harmed, etc. That change then progressively occurred in as much as part of the legislative work that was done started to try to set a norm so that people understood that if you happened to be scubaing and you'd find something, the idea that you were free to take it was wrong. In fact, that's illegal. There then was at some point in the 90s, I think, an amnesty, and I was interested to note that resulted in the return of some 20,000 artefacts and the disclosure of 30 previously unknown shipwrecks. Since that time, like in order for this to work, in the first instance, you want people to just understand that they can't go and take things, they can't interfere with things, they should disclose them properly, and that probably has some effect. But presumably you need to have some other preventative and even reactive measures if it becomes clear that there's the potential for people to interfere with underwater cultural heritage. Is that well resourced? Is that something that occurs now? Do we find that in each and every year there are some instances where it comes to the department's attention or some other part of the Australian government world that something's at risk and that something needs to be done?
Certainly every week something comes to the attention. The program's national program. So I'll just come back a step. So with that decision in the Offshore Constitutional Settlement where states agreed to have the Commonwealth manage shipwrecks, effectively that created the need for what was created, which was the Australian Underwater Cultural Heritage Program. And so the Underwater Cultural Heritage Act is administered collaboratively with the states and the Northern Territory, and the Minister delegates certain powers to achieve uniform national administration to the senior heritage official in each state. We administer the Underwater Cultural Heritage Program and supply money to the states in partial recompense for their activities so that they can do day-to-day management activities beyond just regulatory activities. This is engaging with the public, following up on monitoring sites and doing all of that gamut of activity. And we coordinate that national program so we're having uniform, consistent approaches around the country. So it is a very successful state, Northern Territory and Commonwealth program. It's been running for 40 years as of this year in that collaborative administration, and that's the program. Whenever anything is found within a jurisdiction, the state will, within the program, relevant program, they will try and go and look at the site if possible or follow up to seek further information. They will reach out to the community. So that management component is a very large part of their activities that they do through the program, that day-to-day management, engagement with the public. And they're best placed to do it because they're living in country, working within that whole system. So that's why the collaborative program, which is wedded into the Underwater Cultural Heritage Act, and that was what was agreed in the Intergovernmental Agreement in 2010, why it's so important in the administration of the Underwater Cultural Heritage Act, because it means we all work together in a very collaborative way across the nation.
But are there some enforcement kind of activities that occur? I mean, are there instances where, I assume some of that would happen at state and territory level, but some of it might involve the AFP, where you monitor auction sales, or you see things that are being sold or that privately owned that shouldn't be because they represent shared cultural heritage. or you become aware of people who might literally be going out in boats with gear looking for stuff with the wrong kind of intent.
Oh, definitely. So separating the two, the site and the thing. So artefacts that were recovered prior to the introduction of legislation to protect a site, the obligation on the people from the 1976 Act was that they were required to notify their possession, which was literally just tell the department they had it, and then they would be issued a permit to retain that object, and they could transfer the possession, custody and control of that object through sale. So as long as they met their obligations of notification, they were great in permitting. So we've got a group of objects that are managed through that way, and post-ratification we will continue to manage that because people will continue to have their rights to actually manage those objects in that way. The Convention's purpose is to stop people from impacting sites today and looting and damaging them, and then those objects going off and into the system and being sold for commercial purposes. So we will be having an ongoing management of protected artefacts that are in public possession, custody and control. There is enormous legacy of management activities that are required within that space because it is never, even with the amnesty, there is highly likely that large numbers of artefacts are in public possession, custody and control that have never been reported for one reason or the other. And then someone inherits an object, they have no knowledge and intent to do anything, so we work with them. So we're very much a communication, collaboration, working with people to get a good and fair outcome. Where we have objects where people are trying to sell them and we can actually assess that they've got knowledge and intent to breach, that's when we would be recommending for further investigation, and then something would happen along those lines. So we do that desktop assessment, make that recommendation effectively for the program, so we've got a consistent approach to compliance and enforcement. Let's say from WA discovers something that's wrong, the WA Museum would write to us, who is our delegates area in there, would write to us. We would then do a desktop assessment of that, and then we would make that recommendation to legal if we felt there's sufficient concern for further investigation. And at that point, it's hands off for us.
Yeah. So it seems to me that the difficult part of all of this is where you get outside of your own EEZ, and you're either then in dealing with another country, their territorial waters, or the high seas. Perhaps you could just describe, I mean, one of the points that's made here is that our countries in our region are underrepresented as, signed up and ratified members of the Convention, and so clearly by getting to that point ourselves, it would help in our advocacy and support of other nations in our region to be part of it too. But how else does ratifying the Convention assist us in collaborating with other nations and hopefully having the full benefit and the full enforceability of its obligations for the protection of Australian underwater cultural heritage?
Wonderful question. So the Convention has a de-escalating series of controls. So in territorial waters, obviously, we control whatever. For our own people, we control everything out to the EEZ. But once we go into the contiguous zone and EEZ, we have a diminishing amount of control for foreigners and foreign nationals. But as a ratified state, we can put ourselves up as the competent authority, and we can say to UNESCO, we're happy to manage this site that's been discovered in our waters and take the lead on that, and we'll work with whatever state party that has a vested interest in that site, so a shared heritage interest of some sort, and we'll work with them to produce the best management and protection outcomes for that site collaboratively. It's always around management protection. For sovereign vessels, they retain, if they're out in those waters, they're always another country. So they belong to another country, but we can always work with them for the management protection. The flip side of that, or the quid pro quo of that, is for other countries, such as pick any country where they're managing their heritage in their territorial sea, but they can't and they're not resourced or they don't have the skills yet to lead in the protection of something in their contiguous zone or EEZ. The Convention allows us to say, well, we're happy to step in as the competent authority to assist you, and we will work with you to guide you in how to manage and do that. It's an opt-in thing, so it's not required, but it's an opt-in one. So for us, it's a vehicle for us to help facilitate and capacity build and to help make sure that heritage that is significant to not even necessarily to us as a first party can be managed and protected in a collaborative framework. And that's that multilateral purpose of the convention, to have that. Another side of it is that, as you can see in Article 21 of the convention, you can see that there is a real intent therefore to assist other countries by training them and building up their capacity, by actually helping them not just in maritime archaeology, but in conservation of sites and artefacts, in management, teaching management. So a real part of the convention's framework is not just about communication and collaboration and stuff. It's actually about us taking on a leadership role in this region and making sure that we're giving people the tools and knowledge that they need to actually achieve their own management more effectively, and to try and bring them all up. So it's a big aspect of the convention.
Okay. Last point I want to invite you to say something about before I go to the Deputy Chair is just around First Nations cultural heritage. I mean, when you read through the material, most of the practical references are to shipwrecks that would have been, from an Australian point of view, would have been part of the settlement and pre-settlement era, and then more recently to military vessels, whether they're ships or aeroplanes. It seems that as in other areas of our national life, we're at an early stage of really understanding and properly valuing and looking after First Nations cultural heritage that happens to be underwater. I've tried to follow some of the stories around the discovery and analysis of underwater cultural heritage up around Murujuga in Western Australia, which is timely to refer to today, in as much as the announcement has been made by the government that there'll be a support for a World Heritage listing of Murujuga. But I'm interested in how you think our ratification of the convention can help us make further progress in that area in particular. I mean, one of the submissions we've had, you may have seen from the Australian Institute of Marine Science, actually describes quite a structured process that they now go through in relation to their activities. You know, they're undertaking underwater activities, and they're almost starting from the position that any activity could involve or compromise or affect First Nations underwater cultural heritage, and they therefore follow this four-tiered process for making sure that they're giving that due consideration and also undertaking proper consultation. But I'd invite you to say something about how the convention will enable the further work in that area in particular.
Definitely. The first thing I just want to mention is that currently, should in Commonwealth waters, because that's where the Commonwealth has footprint, if in Commonwealth waters First Nations heritage was discovered, it could then be notified to the department, which is an obligation under the Act, and then it would be considered, and certainly it would then probably be declared protected. So there is a capacity already. What the convention does is the convention brings in from that nomination, it makes it automatic blanket protection rolling date requirement for the protection of all underwater cultural heritage. And this is a fantastic thing, because with making that amendment, we can give clarity within new legislation, specifically identifying that heritage as First Nations or Aboriginal and Torres Strait Islander heritage, so giving that equity, creating an equal amount of protection, so you could marry up the timelines for protection, so we've got that blanket protect rolling date. So there's equity within the process and some clarity about what's being protected. The other thing too is, because the intergovernmental agreement exists and the states have already agreed in principle to do what they can to help, by us having that modelled in our legislation, the states can reflect similar provisions within their legislation over time, bringing us that national consistency so that everyone operating in the marine environment has the same game plan they're operating, wherever they are, in whatever waters in Australia, off the coast of Australia. Consistency, that's where we're trying to work to as a nation. That's the goal. So that's helpful for everyone across the board. For First Nations people, of course, the other advantage for us is, should something be found in whatever waters, we then have to develop a pathway for that communication, consultation, and the whole range of things. For industry who work in the near and offshore environment, for them, actually having clarity around what they're meant to do up front assists them enormously to achieve their business outcomes, because there's nothing worse for a business than to actually discover an obligation later on down the path, and then that slows down their activity. So actually knowing what you've got to do, undertaking your impact assessment, using best practice methods, that helps their business purpose. It doesn't matter what they're asked to do, it's just better that they know up front what they're doing so they can actually plan and achieve it through their whole project life timeline. Where we are with the First Nations underwater cultural heritage is that we will likely end up with that model type of legislation, which will then influence our states and territories. We will work with our states and territories through the program to make sure that we're developing appropriate communication pathways to communities so that should something be found, there is a way to consult and identify somebody who could act or speak for such heritage in further decisions. So there's going to be a whole bunch of work that's going to come out of the convention, which is going to bring up and raise not only people's awareness of and knowledge of the fact that First Nations underwater cultural heritage in this country goes down to possibly around 132 to 135 metres depth and goes through a timeline of 65,000 years. Most of First Nations heritage is between 40 and 70 metres below present, because that's where the coastline was from 65,000 years right down to about 30,000 years. So 35,000 years of occupation was between 40 and 70 metres below present. But First Nation heritage is very hard to find using current methods and techniques. So what we do is we draw an analogy from what happens on land, we model that in the marine environment, and then for industry aren't trying to do research. What they say is, well, if that's highly likely, why don't we go around it? And everyone goes, yeah, that's really clever. And that's what they do. So they use it as a heat map to actually make sure that they're having a mitigated approach to avoid things. But for researchers who work in university or other things, they can use the same heat map approach to actually then test to make sure that they can discover things. And then that helps build that model over time. And that's what we're expecting to have happen in the next 30 or 40 years. Some amazing new discoveries, but also more knowledge and more improvement of our modelling around. And that will again help scientists, community, industry, everyone as we move forward. So it's a really exciting and wonderful space and a very positive space. So yeah, it's going to be good.
Good. Deputy Chair.
Thanks, Chair. Thank you for attending this morning. Do you have a continual consultation and do you link in much with the Department of Veterans Affairs, Australian War Graves and the like, or is it on after a discovery, or is there a maintaining of, if you find a military ship, is there like a report line that you must meet, say, quarterly or anything like that?
No, we don't meet quarterly, but they do buy their coffee. We do meet regularly. We have good friendly association with them. For DVA, obviously a grave is defined by the War Graves Act, and that means bit in the ground with a headstone. So underwater, it's mainly memorialised. Yep. So for us, when we're dealing with DVA, we're effectively always trying to keep them abreast of whatever's happening, make sure they're included in what we're doing, so they're aware of anything. So should anything be on their radar, they're ready to handle it. But on the whole, we work with them, with the Sea Power Centre, which is the Royal and Australian Navy Sea Power Centre. So yeah, so we do talk. We don't do it on a regular basis. We do it on an as-needs basis. Yeah. We're certainly communicating with them around projects that we're doing right now, which is to develop a collaborative management plan for the HMS AE1 in Papua New Guinean waters. So that's one. We'll work with them around the same sort of site in AE2 in Turkey, and then potentially the other Australian heritage around Chinakali and Gallipoli. So we work on an as-needs basis so that we're sharing information and just so we all know what's going on.
Yeah, makes sense. That's good. The if there's a new site discovered or something like that, and would you then make it not available to the public, or at any stage would that, if that's to occur, how do you then communicate it? Is it sort of like what the Great Barrier Reef Marine Park Authority does and has little areas where on a map it says you can't fish? Like, is that how you inform the public? Like, how do you get your message out there?
No. So we've got around 8,000 sites, 7,500 shipwrecks and 500 other sites in the assemblage that we're managing at the moment. It's about 8,000. The reality is there's about 20, and pardon me, I've forgotten the number, probably about 28 sites which have got a protected zone around them, and people are required to seek a permit to enter into that protected zone to access the site. So of that entire assemblage, only 28 of them. Now, one of them is the Yongala, and the Yongala is managed like that so that chartered operators actually take the permit and they take the majority of people to the site. And so they run and check and control most of the activity going on the site, so it's appropriate. Some of the sites that we've got within those protected zones are there for the public safety. So there's UXO, unexploded ordnance, or other issues associated with it. So we say, don't recommend you anchor, things like that, really common sense things. So most of the management framework around the declaration of a protected zone is to assist us to manage a site more effectively and more appropriately, but not necessarily to limit the public. There are two applications where the sites are associated with another country's heritage and they would prefer people not to dive on them. So those sites we actually then manage according to the interests of that country because it's their heritage. But on the whole, the vast majority, should we discover another site, let's say we discover a site that's within a diveable recreational depth of 30 to 40 metres, we probably would initially declare a protected area around it while we're doing the archaeological assessment of the site and understanding its condition and values and issues. Following that, we would then move to opening up the site. The entire program is based around, and this is the entire Australian Underwater Cultural Heritage program, and the Act. The Act actually has within its objectives that the public has a right to be involved both in the science and in the enjoyment of science. So we always have that balance. We're always striving to make something accessible and useful for the public, so that from enjoyment or whatever, from science, at the same time as trying to make sure that they don't damage or interfere with the site in a negative way. And so we use communication as our primary tool, and if we have to, we'll go down the enforcement line. But effectively, most of it's communication as a balance, and we want everyone involved. Some sites, particularly you look in the Great Barrier Reef, I used to be the shipwrecks officer in Queensland, so I know it quite well. And yeah, so we use a lot of those things to manage certain activities around sites, but people can apply for a permit. Very few people who apply for a permit do not receive a permit.
Yeah.
Okay. So that's probably the way. And if we found that we are likely to find another Australian naval vessel at some stage in the near future between Timor-Leste and us. When that is found, it is likely to be at a diveable depth. Our problem right now is we are aware that it's more likely to be towards Timor-Leste than us. So the logic of the convention and the convention's principles of training and capacity building and all that, that is exactly the pathway we need to prepare should something be found like that, if we do not want it to be looted or the human remains of our sailors to be lost.
Thank you.
Thank you. I believe Mr. Pike, who's on the call, has a question. Go to you, Mr. Pike.
I do. Thanks, Chair. It's actually a good segue from the answer to that last question, because mine was about, you mentioned in your earlier answer about the role that Australia has in providing leadership to some of our neighbours in protecting UCH sites, and particularly, obviously, going to be a concern for us in the South Pacific and New Guinea and, Timor-Leste and other areas with, potential, Australian aircraft or ships that have gone down there that may be discovered or have been discovered. What's the level of professionalism or expertise amongst our neighbours currently, and the level of compliance I'm just keen to get a sense from you as to where things currently sit with our neighbours in terms of protecting these cultural sites, and how much room to improve is there?
Quite literally, I think there's enormous potential for improvement, but there's enormous goodwill as well. So quickly running around, Timor-Leste is currently, there is at the community level an interest in professional development, and they're looking at developing an ICOMOS chapter, and that will have a focus on trying to do underwater cultural heritage. We work with Indonesia quite closely, and we have been working with Indonesia for a number of years now. So we're developing stronger relationships and stronger collaborative engagement. Papua New Guinea we work with closely, and indeed that shared heritage management plan of the A1, that's for a site in Papua New Guinean waters, territorial waters. So we're working with them, but there's more scope for development and practical training and a whole range of things. Solomon Islands, we have an MOU with the Solomon Islands to help capacity build and training there. We work with New Zealand every day on different matters, so it's there. Fiji is also very active and keen in moving towards ratification. Tonga has indicated to the UNESCO Secretariat that they're considering the process. So in the Pacific, it's more like there's a lot of interest and desire and willingness to be involved, but until someone steps up with the leadership and training, that's not going to be realised.
Has there been any incidents or basically has there been any destruction or exploitation of Australian sites with Australian significance in our neighbours' waters, or are they? Is it relatively? Has there been any issues in the past that have been of significance to us?
Yeah, in that initial brief chat that I gave, I highlighted that there has been impacts in the South China Sea. The HMAS Perth 1 was heavily salvaged without permission, and the human remains of that vessel were, obviously were not considered, they're just destroyed within that process. So that has been an impact again, but to put it back upon us, did we actively engage and do we actively do anything to make sure that that site wasn't impacted? Probably not. So the convention gives us that ability to actively engage and to say, we're interested in our heritage, we want to be involved, can we help you? So we have that ability to step up.
But in terms of our nearer neighbours, there's no, we're not seeing instances of, destruction or looting or anything like that.
There's certainly issues through different waters in our region. There is a very large population, predominantly I would say more towards north of Australia through that South China Sea region. There's a large history of illegal salvaging and things currently. In the Pacific, it's much more about people going there and taking artefacts associated with World War II, and those countries are trying to manage that either through the 1970 Convention on the Movement of Illicit Objects or in other ways. So these countries are under-resourced but are struggling with this, but they want to improve, and that's what they're indicating.
Thank you very much.
Pleasure.
Thank you, Mr. Pike. It's interesting the comments you make about HMAS Perth and the aftermath of the Battle of Sunda Strait. One issue that's come up in submissions is around the sort of the time requirement. So we've got stuff about the 100-year test, and I mean, obviously HMAS Perth, that tragedy occurred less than 100 years ago. But is it so? Is underwater cultural heritage of that kind still entirely covered by the convention?
So the way that would work is, let's say that we aligned all our heritage at the current level, which is 75 years. That's our blanket protection rolling date. But the reality is we can engage with the convention's framework. We've got that form bilateral relations or multilateral, engage, train, capacity building, work with them to monitor, teach them how to monitor and manage sites. So all of a sudden we're given a range of tools that we can use to help people know that that site's valuable to us and needs to be protected. And we can be a part of the actual monitoring of the site to ensure that it's not negatively impacted with the consent of the nearest coastal state. So a lot of this comes down to our ability to engage early, engage often, and engage honestly with those coastal states, and then to help train and capacity build them. So we're never going to stop looting in the world. We're never going to achieve that. We're going to try and do what we can as a part of a global nation to try and limit the damage that's being done of this nature. That's the goal. That's the purpose of this multilateral agreement, is to try and do our globally to protect this unique and irreplaceable archaeological resource.
Just coming back to some of the details you mentioned before, so there's some kind of register in existence at the moment that has about 8,000 entries on it. As you said, 7,500 shipwrecks and 500 other sites. How many of those are specifically Aboriginal or Torres Strait Islander underwater cultural heritage?
At the moment, almost none, I would say, Aboriginal and Torres Strait Islander heritage indicated on that, because again, from the 3 nautical miles out where Commonwealth jurisdiction is, nothing has currently been located to date, so within those areas. And that's a part of the deposition and the whole site formation process problem. In coastal waters, that's where the states have it. If they have got material that's been located, they haven't put that into the national database at this time. Right. But that's up to the states to do that, because the way the national program works is we have a relational database which we either harvest information from certain jurisdictions who have a database themselves, or for other jurisdictions, they do direct entry into that database and they use it as their sole register. So the Australasian Underwater Cultural Heritage Database is the sole register for Queensland, but WA we harvest information from. So that's how it operates like that all around the country. There are more sites in the database than just the 8,000 we've indicated, because we're also the sole database for other countries already. So New Zealand uses us as their register, their online register, so they don't have the resources to maintain and do one. So it's very simple for us to create a profile for them and they do it. Solomon Islands has agreed to use the register, and so has PNG, so that, again, to help capacity build and enable them over time. So we're working slowly with them to train them how to actually do that work.
And when you say they use the register, they almost use just sort of the database format, but this is for registering sites within their own exclusive economic zones, not for cultural heritage of those countries in our EEZ nest.
Yeah, right. It's
okay, I'll come to you in a sec, Deputy Chair. The Underwater Cultural Heritage Act, does it have the effect? I know with national heritage, it opts on a sort of an opt-in basis. You know, people have to nominate sites and then they get national heritage. So there could be something that, you know, we all know in essence has national heritage, but until it gets listed, that isn't the case. Does the Underwater Cultural Heritage Act operate in a way that it sort of essentially deems items or artefacts or other kinds of instances of human culture to have protection rather than it needing to be assessed first? Yeah. Do you know what I mean? I'm not probably putting that very well.
So one of the very early on in the management of heritage, they started with the idea that you would go and assess a site, identify its values, and then list it. But they quickly realised that it was just such a slow process and sites weren't being protected. So underwater cultural heritage is managed totally differently to terrestrial heritage. It's flipped around. We protect everything on a blanket protection rolling date provision, so it's just once it's certain age, it's protected. And then should work happen on a site, we will then encourage people to understand the significance and value of the site through that period while they're doing that work. So then we get that information that we need later on. So we flip it the other way around. Okay. So blanket protection based on 75 years, and then should someone be doing research or other work around the site, then we expect them to undertake and give us a sense of the values of the site.
And will that be incorporated, or is it already incorporated, you know, as the Australian Institute for Marine Science submission sort of indicates, that they're taking the view, we do stuff underwater, and so in anticipation of the fact that it could have cultural impacts, and particularly in relation to First Nations, we're going to follow these steps. Is it the case that that anyone who wants to go and undertake, you know, could be trawling for fisheries, or it could be a subsea cable, or it could be some other kind of proposal, is there effectively an obligation that's incorporated within the approval process for those kinds of things that picks up the requirements of the convention through the Underwater Cultural Heritage Act, so that they are at least, you know, doing what you're saying, they're turning their mind to the fact that we're about to do something underwater, and we need to be comfortable that what is occurring doesn't destroy underwater cultural heritage?
So everything that you're saying is what we will do once the convention comes into place and gives us that ability to bring that nationally consistent legislative process.
Right.
And we'll work with the states and territories to develop the best practice for people undertaking actions in the marine environment around First Nations underwater cultural heritage, because there's already a well-established regime for historic heritage. So we'll specialise for First Nations heritage, and then that can be imposed consistently and nationally and be developed nationally as a process. So that's literally what we're looking at doing through this, with the conventions, bringing in blanket protection rolling date for all heritage.
Deputy Chair.
Thanks, Chair. I just wanted to confirm, I couldn't remember what you said where you're talking about First Nations people and how so on land there might be cultural heritage area, and then did you say you then flip it to what it could be on the water, or
It's an analogy. So there's been an enormous amount of archaeology and survey work on land around First Nations stuff, and since the 60s, there's been a really well-developed model around where things are likely to be within a landscape. Mm-hmm. So what people are doing, who are researchers in this area, are taking that type of model and then looking at the bathymetry, the sea floor, and they're saying, well, if we look at the same activity sort of system, how does that look underwater? And if it does look the same, where would we be seeing these potential places? High potential, medium potential, low potential. Okay. Where would they be? And they're using that to help them ask questions, research questions, or to avoid impacts.
Yeah, and the reason I ask is I'm from Townsville. My electorate takes in Palm Island. My wife's family's from Palm Island, cool. And the traditional owners of on the land aren't the same as the traditional owners on the from water, right? Yeah. So then the storytelling of the land would be different to the storytelling in the water, and therefore what's replicated here might be different there. And I'm just trying to get my head around that. And I'm sure there's much smarter people that think about this stuff than I. I just wanted to know when this comes up, and I can tell the people that I represent and around the country, this is what they're doing. This is how we're going to ensure that we're not damaging cultural heritage, First Nations people heritage.
And that's where we're trying to go. So you live in an amazing part of the world, and you've got the ability.
That'll be in the transcript.
You've got that area which is pre-inundation, where people walk the landscape for thousands of years, and they've got stories of that landscape and dreaming tracks that go where currently now it's inundated landscape. But they've got thousands of years of knowledge of where they walked, and they've got thousands of years of heritage of sailing over and fishing in the same environment. Mm. It's one of the great wonders and beauties of Australia, this layered knowledge over such a length of time. So what we're trying to do is get to the stage where everything is effectively protected, and then we work with everyone to how can we manage it most successfully so we're doing the right thing for everyone. It's slow process.
Yeah, no, thank you for the answer.
Yeah, I mean, that's probably a nice point to end on. I mean, clearly the convention, I mean, I know being the representative of a community that takes sort of heritage very seriously, the community that I represent anyway, understands that it's about protecting on the one hand, but not protecting it by locking it away somewhere that nobody can ever see it. But we just have the confidence that it's now kept in a sort of a sterile enclosure or something like that. Like, actually, heritage is about making sure that we all continue to benefit from something that is our shared. It's a shared resource. It's something that we should learn from and enjoy. So clearly that is part of how the kind of convention. The convention includes that. You've spoken already about the fact that you want to make sure nothing is harmed, destroyed, or disrespected. But then separately to that, it improves the way that people can know about and in some cases see and experience heritage. One of the things I guess I'm interested in is how you set those terms and those arrangements, because of course, like in Fremantle, we have the Shipwreck Museum, and it consists of lots of actual fabric from the Batavia that is now not on the seabed, but in a room in Fremantle.
Yeah.
And there's other heritage in the museum in Geraldton as well. So perhaps you could just speak to that aspect of the convention, how it's sort of designed to shape the best way of preserving, but also enabling people to interact with and experience cultural heritage.
Absolutely. So you're exactly right. The convention enshrines the right of the public to access sites and be a part of it. The convention's focus is what they call on in situ preservation as a first option. So leaving it underwater and managing it underwater as a first option. It's an option. There are other options. The truth is that to engage the public, some of the public dive, a lot of the public don't. So there has to be a structure. And in archaeology, when you do an excavation and you are taking out artefacts and then telling that story that comes from what you find, that's what you communicate. So within museums and displays, that's the purpose. So whilst we don't recommend a private individual selling an object they've recently found, we do recommend that object going into a museum and being interpreted and displayed so that the public learn about it and actually learn about the wealth of their own heritage. So that's where it goes. So both things are meant to be in there. If you're trying to manage sites in situ, your focus has to be on taking people and getting in the water and monitoring the changing condition of those sites, because the condition does change over time. And if a site is threatened through human or environmental purposes, then we need to flip from an in situ focus to a targeted research focus of excavation so that we're recovering information before that site is totally lost to our heritage.
Okay. All right. I'll just ask you to take one question on notice, if you don't mind. You said about the 8,000 that almost none of them would be First Nations related. So but if you can tell us if any of them are, that would be useful. And also, while obviously it's for states and territories to notify of First Nations heritage that they may have identified, have registered. Again, even if just anecdotally you're aware of that being part of the work that states or territories have done, even if it hasn't made its way onto the register, I think it would be worth us just having that information.
Pleasure.
Okay. On that basis, thank you for your attendance here. I've just asked you to provide some additional information, and I need to ask you to please provide it to the Secretary within 7 working days. That's how we operate. And it's your responsibility to meet the deadline in a timely manner. You will be sent a copy of the transcript of your evidence when it becomes available and have the opportunity to request corrections to any transcription errors. But otherwise, thanks for your work over a long period of time and for being with us here today.
Thank you. Thank you.
Appreciate it.
Good luck.
Sure, we'll go and look at the transcription.
Thank you, everyone. Have a lovely day.
Thank you. All right, we are going to move on. I welcome Dr. Mark Staniforth and Ms. Danielle Wilkinson from the Australasian Institute for Maritime Archaeology and Associate Professor Wendy van Duivenvoorde from Flinders University, the Maritime Archaeology Program, to give evidence today. For the Hansard record, can I ask you, please, to perhaps in that order, please state your full names and the capacity in which you appear before the committee. So,
Staniforth, I'm an individual witness before the committee, so that's my role.
Thank you.
Hello, I am Danielle Wilkinson. I'm President of the Australasian Institute for Maritime Archaeology.
Thank you.
Good morning. I'm Wendy van Duivenvoorde. I'm an Associate Professor in Maritime Archaeology at Flinders University.
Thank you, Professor. Apologies for my first attempt at pronouncing your name. For that, although the committee doesn't require you to give your evidence today under oath, I should advise you this hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence you give today will be recorded by Hansard and it attracts parliamentary privilege. So I'm going to invite each of you to make some opening remarks, if you would like, before we ask you some questions and have a discussion. So again, perhaps we'll start with you, Dr. Staniforth, and then Ms. Wilkinson and Professor Van Wievenvoorde. I'm not sure I'm getting better at that. Dr. Staniforth.
Okay. I have been involved in this field for very nearly 50 years, since 1974. And that's very nearly as long, it's longer than the Commonwealth has had legislation in this particular area since 1976. And so I have been involved in, as an individual and in various organisations over that time, including working for the Victorian State Government, for the Commonwealth Government at the Australian National Maritime Museum, and for some years as an academic at Flinders University, where I established the Maritime Archaeology program. I suppose some of the comments that I'm interested in making are, there are now, I think, 72 of the 195 UNESCO countries have ratified this convention, which is about a third, which is a significant number. I have previously argued that there are three important factors at work that affect the ratification of UNESCO conventions like this. The leadership factor, which I think is where a regional or a lead country ratifies and other countries follow suit. The neighbourhood factor, where one or more of your immediate neighbours ratifies the convention, and that often prompts the country to consider and sometimes actually ratify. And then there's the common language or common culture factor, where a group of countries that share a common language or a common cultural heritage ratify the convention. Perhaps the best example of this is Latin America and the Caribbean region, where approximately 21 of the 32 countries of the region have ratified the convention. And so that's more than 65%. When Australia ratifies, it will have an opportunity to play a leadership role in the Asia-Pacific region. So, for example, when I went to New Zealand some years ago and spoke to representatives of the New Zealand government, they said that New Zealand would only ratify if Australia ratified. Indeed, if Australia ratified, then New Zealand would be almost certainly encouraged to ratify by the ANZ Cultural Ministers' Council. Now, the Asia and Pacific region of UNESCO has the lowest rate of ratification of any of the 5 UNESCO regions. Only 4 of 46 countries, or less than 10%, have actually ratified in our region. Half of these ratifications have happened in the last 5 years, and I think a few more ratifications, particularly if it included one or more of the lead countries in the region, like Australia, would see the neighbourhood factor come to the fore. So I think Australia has this opportunity really to be a lead within our region, and if Australia led 1 or 2 other countries, I think the neighbourhood factor might come into play, and we might see the Asia and Pacific region come from effectively the lowest rate of ratification up to something approaching what you might consider a normal rate of ratification. So from something under 10% to much closer to, say, 30% of our region. And that would massively increase our ability to work effectively with our regional neighbours. And that really is the key element that I see this convention doing. So those are my initial comments.
Thank you. I appreciate that. Ms. Wilkinson?
Thank you. I'd first like to express my thanks for the opportunity to take part in this hearing alongside my esteemed colleagues. The Australasian Institute for Maritime Archaeology, or AMA, is an incorporated non-for-profit organisation based in Australia that is dedicated to the preservation of underwater cultural heritage. AMA members include archaeological consultants, Australian state and territory practitioners, researchers and academics that all reference the principles of the Convention as a standard for their work ethic and practices. AMA is also an accredited non-government agency under the 2001 UNESCO Convention. The NGOs provide knowledge of current practices and issues in the field of underwater archaeology. In this capacity, we attend international meetings with other accredited NGOs around the world and assist the Secretariat of the 2001 UNESCO Convention. The accredited NGOs also cooperate with the Meeting of State Parties and the Scientific and Technical Advisory Body to the 2001 UNESCO Convention. Our institute has long been a supporter of the 2001 UNESCO Convention and has been actively educating and implementing the principles of the Convention within Australia. Ratification would strengthen our current standard of practice within Australia and the protection for Australian heritage located within Australian waters. It would also provide new protection for Australian heritage located internationally, opening new international cooperative opportunities with other states, particularly where we have shared heritage. Thank you.
Thank you. Professor van Duijvenvoorde?
Thank you very much. There we go. I too would like to thank the Standing Committee for the invitation today. As part of the Maritime Archaeology Program at Flinders, which was established in 2002 by Mark Staniforth, I'd like to participate as a representative of the largest and most successful postgraduate program in the specialization of maritime archaeology and underwater cultural heritage. We train students to become professional in the field of underwater cultural heritage and their management. And as such, we, over the last 20 years, have worked closely with AMA, but also the state and Commonwealth governments in their respective shipwrecks or maritime heritage programs. And most of our graduates are actually employed as state practitioners or practitioners within the wider field in Australia and abroad. We have an international student base, so not just Australian, and our graduates have gone on to work for national and state government institutions, museums, universities, and consulting firms, both here in Australia and abroad. Now, we attend over the last 10 years, we regularly attend the UNESCO state meeting, annual meeting in Paris, usually on underwater cultural heritage management. And we're also one of the founding members of the UNESCO University Twinning and Networking Program for Underwater Archaeology. Just like with the UNESCO Convention, Australia has played a large role in the drafting of the convention, as well as the UNESCO UniTwinning program, which supports the convention and aims to increase the capacity and research in participating countries through international cooperation. And so for us, it would also, of course, be really beneficial to see that ratification, not only for the reasons that Mark Staniforth pointed out, which are by far the most important. So the regional lead, like being a player on the international scene, but also the neighborhood effect. And it will also for us really increase the capacity and the ease that we work internationally with our neighbors, with other people in the region and abroad, away from our local region in shared heritage projects. So Australian heritage abroad, or looking at other countries' sites in Australian waters.
Thank you. And look, I might stay with you and then come back around to your fellow panel members. Do companies that operate in the marine environment or organisations that operate in the marine environment make proper use or sufficient use, in your judgment, of the marine archaeological expertise that exists, with a view to being mindful of underwater cultural heritage? Is that one of the things that happens, within Australia and internationally?
Yeah, mainly in Australia. Our state heritage agencies often get contacted by consultancy companies, by mining industry, and other commercial venues if it comes to development or undertaking other projects. And that's quite a watertight, I think, process where, for permitting, consultancy, assessments, to see whether heritage is protected and stays protected or not, or whether there needs to be mitigation. It may go wrong once in a while, but I don't think that happens that often, because those processes have been in place for so long in Australia. And we've had that legislation for decades. Beginning with Western Australia in the 1960s.
We heard before from the departmental representatives that with respect to the cultural heritage register that's operated nationally, there's 8,000 entries and 7,500 of them are shipwrecks, and then so on and so on. There's not much on that register, if anything, that is in relation to First Nations cultural heritage. I just invite you from your point of view as a someone who has very significant expertise but is also involved in the building of that expertise through an archaeology program, just to give us a sense of how First Nations, Aboriginal and Torres Strait Islander cultural heritage is part of the consideration and training that archaeologists in this area undertake, and to what extent that has sort of changed in recent times.
Yeah. So in the last 10 years, we certainly have attracted faculty, but also research programs and teaching programs that are related to submerged prehistoric, what we call submerged cultural landscapes, for example. So that's what Andy Fiduka discussed earlier, with those landscapes that were walked up on and lived up on for thousands of years before they got inundated. And if it comes to watercraft, for example, there is very little on that register. When we're talking about the 8,000 shipwrecks in and around Australia that have been identified and that are protected, they're mainly colonial. And some of them are pre-colonial, but they're still Western. Think of Western Australia with the Dutch shipwrecks, the early Dutch shipwrecks from the 17th and the 18th century, or the Trial, our earliest known early colonial vessel from 1622. There have been reports in the past of watercraft, indigenous watercraft, appearing and emerging in archaeological context. But usually that's after flood events, and that disappears again. And there are some museums that have indigenous watercraft that have come from that context on display. So it does exist, but there's nothing that we know of, or very little that we know of underwater related to that. But having said that, of those 8,000 shipwreck sites, a lot of them have, again, that multi-layer interest on them. So they may be colonial, but they certainly have storylines, they have dreamings, they have narratives that are very important and are related to First Nations people. So they're not just a colonial shipwreck, because there are plenty of examples of those.
Sure, thank you. Ms. Wilkinson, I guess I'll also sort of ask you your view. With these things, you end up with an international agreement. It sets standards and objectives and principles, but we know in lots of areas that you do need matching capacity and resources, I guess, to see these things made real. I'm just, invite you to say something about that side of the cultural heritage enterprise in Australia. Are we in a good position in terms of research capacity and other related resources to make sure that we can, in a sense, live up to the potential of the convention, both within our own exclusive economic zone and then more through collaboration with other countries where Australian cultural heritage exists in a marine environment outside our EEZ?
Sure. I think in responding to that, my answer is almost in two parts. First, dealing with shipwrecks and that more historic heritage, which has been protected in Australia offshore for a lot longer. And a lot of our industry for the last 20 years has been acting in line with the convention and the annex to the convention. For example, AIM's constitution has it written in there to support the aims and rules and articles of the convention. And our code of ethics says to support and comply with the terms. So all of our members, including people working in state and federal government, including consultants and those in academia, have already been working in line with the convention for decades. So it's well supported, and we do have the resources to a large part to support implementing the convention within Australia in that way. When it comes to First Nations heritage, that's a very developing area at the moment that's getting a lot of focus amongst the professionals. And it's certainly an area where we're trying to build expertise and the scientific knowledge base and the connections and consultation strategies to manage First Nations heritage underwater. And that's very active at the moment and quite promising, I'd say, especially with the Flinders University program and the students coming through there that have training in submerged Aboriginal heritage as well as maritime archaeological practices. But there's still a lot of work to be done in that regard.
Okay. Obviously, as you say, like the convention came into being in 2001. We had a very significant role in drafting it. To some considerable extent, we've based what we've tried to do here in Australia on that. So it's not as if ratification is going to bring Australia from a kind of a divergent position into conformity. To some degree, we've been trying to operate in compliance with the principles of the convention for some time. But you made reference. You made reference to the fact that we have participated in meetings of the state parties and other UNESCO-related multilateral fora. How do you think that will change our ability to participate? The ways in which we will participate might change and improve once we get to the point of having actually ratified the convention?
I think it will change considerably, mostly because of that extra support for international cooperation on projects. Australia will be seen with much more esteem when it comes to leading ethical projects overseas. And as Mark outlines, that once we ratify, there's that neighbourly effect of other countries within our area ratifying as well, and a much larger strengthening of opportunities for international projects. It's within our capacity as AIMA as an NGO. We're there with a lot of other representatives from organisations around the world, and some countries have ratified and some have not. But Australia has always been seen in the context of sort of international standings as a leader in terms of our approach to managing underwater cultural heritage. It's been almost unfortunate that we've had to wait 20 years to get to this stage of considering ratification. It's almost embarrassing in terms of our industry. It's taken this long. So once we do ratify, we'll be held with much better esteem, and there'll be a lot more opportunity for that international work to happen.
You may not be able to answer this question, but I'm just interested. Is there significant kind of appetite and interest from young people, high school leavers and university entrants to go down the sort of marine archaeology path?
Wendy might be able to answer this question better than I do. I think maritime archaeology captures the imagination of a lot of people. A lot of people wish they could study this and go into the industry. It is a growing industry in Australia, and so there isn't as many, I guess, job opportunities as you would like to have available to emerging students, but there's still a number of students passing through the Flinders program. And I think that after ratification, that would certainly be increased. We'd be recognised worldwide as a country that meets that ethical standard. And yeah, there's a lot of potential for growth after that as well.
Okay, thank you. I'll come to you, Dr. Staniforth, and then I'll go to the Deputy Chair. You've and I appreciate the three factors that you identified at the start. That was very helpful. I believe you've written about and have some knowledge of the circumstance in which we see the worst kind of behaviour or conduct in relation to underwater cultural heritage, essentially a form of piracy, I suppose, that sort of treasure hunting. I would take it that doesn't occur in the Australian jurisdiction, or must be very limited, or to the extent that people end up improperly with cultural heritage in their possession these days, you'd expect it would be perhaps inadvertent sometimes. But is it something that is happening a lot in other parts of the world, and particularly in our region? And do you think that it's something that that Australia and other countries are sufficiently proactive about trying to identify and combat?
Well, I think the fact that Australia has had legislation now for close to 50 years, and we have been trying to conform to the UNESCO Convention for 20 years, that has had a real effect inside Australia. And so the things that went on in the 1960s and 1970s no longer happen inside Australia. It's no longer possible or acceptable for people to take material from shipwreck sites inside Australia. So we've been really, really effective in those terms. However, for some years, Australia was a net exporter of treasure hunters. And so what we were doing was we had people inside Australia who were going to our neighbours and being involved in treasure hunting. And that was a significant issue through the 1980s and 1990s. And so we were not necessarily viewed by our neighbours as a friendly sort of place for helping them with their own underwater cultural heritage, and that was very unfortunate. That made our lives very difficult. Unfortunately, through that period, it became increasingly difficult for Australian treasure hunters to go overseas, both from the point of view of overseas countries becoming more involved in this, but also from the point of view of Australia making it much more difficult for treasure hunters to, say, bring back material from overseas and then get involved in selling it in Australia or overseas. And so there were a number of cases where that started to stop our net export of Australian treasure hunters. So that's been quite good as well, and that has changed people's views of Australia over the years. And I suppose the problem that we've had since the ratification that the convention came in 2001 is that the very first question that comes to me from my overseas colleagues in the region is why has Australia not ratified, given the circumstances and the history of Australia's involvement in this? And my response, sadly, is I really have no answer for you. I have always thought for the last 20 years that it's very unfortunate that we have not ratified, because so many of our neighbours would like to see us ratify. And so at conferences in the region, they would like to see Australia ratify this convention. And so I think that's going to suddenly start to improve when Australia does ratify. And hopefully that will become a past issue, like Australians exporting treasure hunting to the region. So carrying on from that, does treasure hunting still happen in the region? And the answer is very much yes. And I have written on this as well. I worked for 10 years in Vietnam, and Vietnam had a long period of involvement with treasure hunting and the sale of underwater cultural heritage. There have been significant issues in a number of countries in our region, in particular in some of the ASEAN countries, which have resulted in Australian relevant material, such as was spoken about before, the HMAS Sydney material, which has very largely been damaged or destroyed. And that sort of thing was a real problem, and to some extent remains a problem within the region. And that will be very much affected by some other countries in the region starting to ratify and Australia providing leadership. So I think those two factors will start to come in, and Australia will provide leadership and perhaps training and cooperation in a more sophisticated way. And I think that will improve the situation in our neighbours, because when Wendy talked about program at Flinders, it is the only program in the region, really. And that's one of the things that we have to appreciate. We are automatically a leader in this field already, whether we have ratified or not. But once we ratify, I think it will help us enormously in our relations with our neighbours who currently look at us and go, why has Australia not ratified? You know, that question is always posed to me and to others when we go into the region and try and work with them.
All right. Thank you for that. I appreciate that. Deputy Chair.
Thanks, Speaker. Speaker.
Well,
I was practicing something else in my head.
You've got the best seat. You've got the best seat in the country, and I've just got a promotion.
Yeah, don't tell Milton. Ms. Wilkinson, your colleagues around the world and in other nations, in particular the United States, United Kingdom and New Zealand, they have not ratified the convention. What are they saying to you, and what's your views on this?
Particularly in the UK, I've worked there before, and their legislation is particularly troubling when it comes to the protection of underwater cultural heritage. But in the reverse, they also have a very passionate population wanting to protect their underwater cultural heritage. So you do have two extremes there. Looking at Australia, though, they know that our legislation is strong. They know that we've been a leader in protecting underwater cultural heritage, that we run by a very high standard of ethics. So it is, like Mark explained, it's quite confusing to them as to why we haven't ratified. It seems to be quite a simple step compared to the struggles that they would be facing to try and ratify. And I think, as someone mentioned previously, for New Zealand, they're just looking for our example. And it's that neighbourhood effect that Mark discussed. Once we ratify, there'll be a snowballing effect, I guess, across the Pacific of other countries following our lead. I can't speak to the US though, unfortunately. But yeah, that's my impression from the UK and New Zealand.
Thank you. That's the only question I had, because I know that you'd be linking in with everyone in your profession around the world, and why they haven't, what their thoughts are, can it happen, or is it waiting for us? And I take yours and everyone else's comments around this has taken a long time, and I do appreciate your contribution.
Thank you. We have some questions, I think, from Mr. Pike.
Yes, thanks, Chair. My question just follows off some of the comments that were made earlier about deliberate looting not necessarily being an issue in the Australian context, or at least not within our waters. But what I would be interested to get from each of you, if from your perspectives, are the biggest threats to Australia's underwater cultural heritage? And then while we're going around, I'd also be keen to know, just out of interest, from a maritime archaeological industry perspective, is there a big holy grail on the horizon? Is there something that the sector's working towards? I'm keen to know what the next big thing is, or at least what the industry's excited about at the moment.
I have some very strong thoughts on that, if it's okay for me to go first.
Yes, you go.
I've worked as a consultant at interstate government, so I'm speaking partially from that experience in my answer. To me, at the moment, the very big pressing matter is submerged First Nations heritage. In Commonwealth waters, the protection, as you heard from Andy, is only with a declaration from the Minister, and that's just not cutting it. We really need much stronger protection for submerged First Nations heritage, particularly now that there are much higher risks in the future with offshore wind farms and huge offshore impacts as a result of those. I've worked in the UK on offshore wind farms, so I'm a little bit familiar with the processes of mitigating impacts there. And it is going to take a lot of cooperation, a lot of collaboration with First Nations peoples in working out appropriate mitigation for those wind farms. And to do that, we need strong legislation as well, in order to almost force the hand of developers to actually participate in all of those steps to achieve a good result. Things coming up in the industry is offshore wind farms, and a lot of research needed offshore through development-led research or academic-led research to understand our offshore landscapes, and to be identifying those areas, like Andy mentioned, of like hotspots where there might be archaeological sites. It's a huge developing area at the moment, which I feel has just launched astronomically in the last few years alone. But ratification of the UNESCO Convention will have massive impacts on that for good, for protection of First Peoples' underwater heritage. That's my piece. Thanks.
I invite Professor Van Wievenvoort or Mr. Staniforth, if you'd like to respond to that.
Yeah.
Wendy, you're on mute.
Sorry. I underwrite everything Daniel just has said about the submerged cultural landscapes and the impact of developers there. When I look at our maritime archaeology program at Flinders, 80% of our graduates find employment within the industry, and that's mainly state heritage or museum or consultancy positions and jobs. But with the opening up and the shift of focus to include submerged cultural landscapes and those type of sites, and especially having all these offshore developments going on, that will be a real opening for our new graduates to get employment. And we think that will take off in large numbers.
I suppose my comment relates to the teaching and training of underwater cultural heritage managers and maritime archaeologists, and that is that one of the things I have been disappointed in over the, say, last 20 years of the development of the Flinders program is that we have a very strong individual program there, but not enough of the other archaeology programs in Australia have done anything about teaching underwater cultural heritage and maritime archaeology in their programs. I think it's about 38 universities teach some form of cultural heritage management and or archaeology, and I don't think almost any of them have a significant or meaningful maritime archaeological or underwater cultural heritage component. And that means effectively that everybody who gets trained has to come to Flinders in Australia. Danielle was one of our students years ago, and I think, you know, most of the people that you look around, Andy Viduka was one of our students. I mean, they've all gone through the Flinders University program, and I think one of the great disappointments is that Australian universities involved in teaching this at a general level, archaeology and cultural heritage management, have not done enough to incorporate that so that archaeologists and cultural heritage management people who work in other fields have at least a sense for what underwater cultural heritage management is about. And it is different. It is distinctly different. And if they don't get any of that in their training, I think that's going to be a problem going into the future.
Thank you very much. That's all from me, Chair. Very interesting answers.
Thank you, Mr. Pike. Look, I've really just got one further thing based on some of the comments that were just made. Just for you, Ms. Wilkinson, based on the experience that you had in the UK with respect to wind farms, I mean, obviously Australia has that kind of offshore project now before us. We haven't had offshore wind yet, but it's in prospect. Presumably, other kinds of offshore development that we have had, oil and gas or certain kinds of fishery operations, but particularly trawling operations, previously would have taken place or been considered through a process that's probably not as good as we would like it to be, and the ratification of the convention now gives us the opportunity to do that better going forward. But from your experience in the UK, I mean, I take it that principally what we want is to have that framework and those processes of high quality so that you can give proper consideration to cultural landscapes and then design development appropriately. But I'm interested in the extent to which where you've been involved in it, where presumably you've seen it perhaps done in relation to those kind of developments, whether that's how it works. You know, does it become something that can be done properly with the application of maritime archaeological expertise, so that people wanting to put in place a development that has benefits like offshore wind or previously oil and gas can still do that. They just make sure that they're doing it with the proper protection being accorded to cultural landscapes.
Yeah, absolutely. It's obviously a bit of a different situation in the UK in that they're not dealing with an alive culture associated with sites underwater. So their approach is primarily more of a scientific rather than, it's a scientific approach really. And wind farms do have a very large footprint. It's a very large footprint, but the turbines themselves are, I guess, relatively confined. So there's kind of two approaches to this. The first is understanding the landscape offshore, and that's through geographical surveys, through coring, and that being interpreted by someone like a geoarchaeologist to create almost a map of the seafloor. And that's where the methods that Andy described about looking for, say, features and then identifying hotspots for heritage might be identified. And at that stage, you can use, I guess, a kind of avoidance or exclusion so that the wind farms or any other developments avoid those high areas of sensitivity. When it comes to the wind farm itself, despite having a very large footprint, the turbine, the direct impacts from the turbines adds up to quite a small impact relative to an entire landscape. So generally, those impacts are mitigated by research, by the boring that takes place, the cores, and having those interpreted by a specialist to identify, say, peat layers, or it just adds to that cultural landscape, and looking for artifacts that might indicate a specific site. By that stage, the impacts have happened for the most part, but the research opportunities that come from those is what's of value, at least in this UK model. I'm thinking that could almost be applied in Australia as well, but obviously there'd be a lot of communication with registered Aboriginal parties or the First Nations peoples to see whether that research, mitigation by research is enough, is satisfactory. We don't know much about our offshore landscape at all. Any research, any learnings we can gain, even if it is in the process of a development, is of national importance. Finding out that information. So, I guess it is a twofold approach. There is a chance for avoiding key hotspots, but then the impact of the turbines themselves relative to a landscape can mostly be mitigated through research, possibly. Does that answer your question?
Yes, no, that's very helpful. I would just invite you, if you don't mind, I mean, if through your experience you're aware of a kind of an industry standard or an applicable protocol or guidance note or something that essentially has been used in the UK. I mean, UK has made more use of offshore wind than just about anyone else. So they've clearly got considerable expertise in undertaking the kinds of things you've talked about, and you've been involved in it. If there are any documents like that or websites that contain that kind of guidance that you'd like to bring to the attention of the Secretariat, I think that would be worthwhile for the committee to be able to consider.
Yeah, sure. Offshore development has been, I guess their process for mitigating impacts has been developed over 20 years with a lot of refining along that time frame. So they do have some very clear guidance documents, and I have a package that I can send along to the Secretariat after this if it's useful.
Okay. Well, thank you. And thank all of you for your attendance here today. We acknowledge the considerable expertise you bring in providing that evidence to us, and also your advocacy in relation to cultural heritage over a considerable period of time. I have just asked Ms. Wilkinson if you could provide some point us to the package that you mentioned, and please forward it to the Secretary within 7 working days. That's just the time frame by which we need to operate. And I'm obliged to say that it's your responsibility as a witness to please meet the deadline in a timely manner. All 3 of you will be sent a copy of the transcript of your evidence that you've given today when it becomes available, and have an opportunity to request corrections to transcription errors. But again, thank you both for your submissions and for your time today.
Thank you.
Thank you.
We're fortunate to have Dr. Hardesty with us, so I invite him to come forward, and we will move on. I welcome Dr. Paul Hardesty, the CEO of the Australian Institute of Marine Science, to give evidence today. For the Hansard record, could you please state your full name and the capacity in which you appear before the committee?
Paul Hardesty, Chief Executive Officer of the Australian Institute of Marine Science.
Thank you. The committee doesn't require you to give evidence under oath, but I need to advise you that this hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I invite you to make a brief opening statement, and then we'll proceed to discussion and questions.
Oh, thank you, and nice to see you guys. Yeah. Basically, we provided a submission in writing. It's short. It's about 2.5 pages long. I'm just going to take that as read, if that's okay. I didn't prepare an additional opening statement. I'm happy to answer any questions or elaborate any of the material or ideas that are in here.
Great.
That's all right?
Yep. No, that's perfect. So I'll kick off, and then we'll go around. It was a really interesting submission. I mean, I've referred to it a couple of times already today, partly because you describe a sort of a proactive methodology that AIMS has sort of undertaken with respect to underwater cultural heritage of Aboriginal and Torres Strait Islander peoples. And so, I think it's worth it for the sake of the broadcast and for the transcript, if you don't mind talking about that. I mean, you've got this 4-tiered approach, which seems very sensible. I mean, first of all, I guess, where did that come from, and how have you found? Perhaps you can mention what it is, the bronze, silver, gold, and platinum tiers, but how you arrived at that, and then how it has worked in its application.
Okay, great. Well, there's a lot behind it, so if I get rambling and too enthusiastic, just slow me down. But look, when we set ourselves to develop a new strategy for the organization, when I first started as CEO 5.5 years ago, one of the things that we did was we did a very extensive stakeholder canvassing of their views, and there were some very simple questions, and one of them was, what do you need from your National Marine Science Agency going forward? And we got about 250 responses from across the country, industry, government, communities, traditional owners. And one of the things that popped out as a very, very consistent message was that AIMS operates in the north. We're a northern agency. We work above the Tropic of Capricorn, essentially. You need to seriously up your game in terms of how you engage and partner with traditional owners and Torres Strait Islanders and Aboriginal peoples who live in sea country, and have lived for a long time in sea country. And so we took that to heart, and we started to look for ways that we could make it more than just lip service. To be frank, a lot of organizations, private sector and so on, the commitment to that area is, let's acknowledge country and we'll do a smoking ceremony, and it's all good. That stuff is all good. Don't get me wrong. But we wanted to find ways to embed it into the core of what we did. And so we decided to make it integral to every piece of research we do, that we're not just engaging with traditional owners, but we're partnering with them. And that's a very different thing. Those two words are totally different. And so we don't call it engagement. This is engagement. We call it partnering, sitting down together and doing stuff, figuring stuff out, understanding what each other needs. And part of that was that we recognized that over the 50 years of our history, that we had always gone to sea country. We had taken samples. We had done invasive activities on the seabed. We had probably interfered with areas of cultural heritage, and we had never communicated that with any of the traditional owners. We just come in, we have a permit, we have the legal right to do it, and we do it. And so what we decided was a number of things that we could do, and we packaged them up in those various silver or bronze, silver, gold, platinum, to talk about the levels at which we could engage, partner. And one of the critical aspects for this was free and prior informed consent, FPIC, which is a UN concept. I believe that we're the first government agency in Australia to enshrine, both in policy and practice, the requirement for free and prior informed consent for any activity in the silver category, where we're actually going to site and taking samples or doing anything intrusive, right? Doing anything on the bottom, putting cameras on the bottom, which we often do, collecting samples of core, fish, all kinds of invertebrates, etc. And what that means is that if the traditional owners, when approached, and when we talk about what it is that we're planning to do, if they say no, then we don't do it. And of course, there's big risks that come with that when you're engaging with big projects that cost lots of money and involve people and ships and vessels and time. All that's being planned out, and if that prior informed consent isn't achieved, then that's a risk to the organization. But we believe that it was a risk well worth taking, and so that's really at the core of those levels. The other aspect that's at the core of those levels is the degree of integration and partnership. So the bronze really applies to, desk studies and things like that, where we're not going to site really, we're just reviewing information or something. We will still engage with the traditional owners of those areas where we're working with, tell them what we're doing, invite them to have an opinion or participate. But when you move up to silver, that's when we're going out to the field and doing the kinds of things that I was mentioning. Then free and prior informed consent is a requirement. and it's now a policy that's officially endorsed and owned by our board, our council, as a statutory authority. So it has that force of governance, and then we as the executive apply that. And it doesn't matter if we're working for a government project or for a project with industry. So for instance, we just had one working with Woodside near the Perth Canyon on pygmy blue whales. And we realized that we've been doing that project with them for years. And well, we never got FPIC, right? So as we implement this, we're now having to grandfather it back into projects. And of course, you're talking to the companies, and at first it's, well, we've been doing this for years. Why are we changing? Well, because we're moving forward, because we're advancing this agenda to, I think, the betterment of everybody. And so that was a really interesting case history, if you don't mind me saying so, because when we originally approached that particular group, the first answer was, well, no. And the reason is that they did not know what we were asking of them, because nobody had ever asked them that before, even in their terrestrial lands. So it gives you an idea of the step-out nature of that a lot of this incorporates. And then look, gold is simply the fact that that's completely co-designed. Any project that we do is co-designed and co-implemented. So there are ranger groups, citizen scientists, training, knowledge sharing. Participatory mapping is a big part of what we do. So and I think it's super applicable for this, because we'll sit down before we go and work in that area of sea country, and we'll sit down with the elders and with the rangers and people who use that sea country. And we'll provide our maps with our science, remote sensing, et cetera, and they will now start to imprint the cultural information. Ecological cultural knowledge, but also traditional knowledge of cultural sites of importance. It's a really powerful thing, right? We did it with, we're doing a big project in the Keppel Islands with the Whoopabara people. And again, first time that they've ever gone through this experience. Nobody's ever asked them to do anything like this before. No one's ever asked them permission before. We didn't. We've been working there for decades. One of the first things we do in all of these processes, there's a truth-telling exercise where we put up our hand and we say, look, telling the truth. We've been here every year for 40 years. We're not, it's not really an apology, it's just a truth-telling to move forward. And it's a really important cathartic experience. But in that particular area, there's these caves off the coast, and they're called the punishment caves. And that's where the traditional owners were chained into these tidal caves to be punished. And sometimes they'd drown if the tide came up too high. So you can find those areas of cultural importance, map them out, and make sure that when you're doing your work, number one, they're recorded, they're respected, they're acknowledged, but then they're not interfered with in any way that might damage them. So these processes, I feel, and I think at the core of our submission, the things that we're doing, I think are really, really critical to actually making the kind of convention that we're talking about actionable. It's good to have a convention, but you got to actually be able to do something. And you can't do stuff if you don't know where it is and what the importance is. So that partnership level is super important. And Platinum is led by the traditional owners, 100%. They come to us and say, here's what we want to do, here's where we want to do it, when we want to do it, can you help us do it? But we want to lead it. And we say, yeah, fantastic. So it recognizes that those are improving levels of partnership. I'll stop there because I'm.
Yeah. No, look, it's great. It's a great description. It's exactly what you say. I mean, we know that we ratify agreements, particularly international agreements, and then we live up to them and we sort of implement them. But how that happens in practical, real world ways is not always easy to understand at the outset, and certainly from the committee's point of view, and I think from the point of view of the broader public. I mean, clearly part of what you've been doing, I think it seems entirely consonant with what's at the core of the convention, which is respect and protection of, but also a greater capacity to sort of share and understand and benefit from cultural heritage. I mean, we had people before saying the convention doesn't exist just to identify that something has heritage and then leave it alone altogether, make sure that nothing ever happens to it. I mean, in many cases, part of the idea of the convention is that you do protect and respect things and enable them to be shared and experienced appropriately. And clearly, some of the protocol that you've implemented goes to exactly those kinds of things in a very real way. But they're not, unless you correct me, they're not things that the convention specifically calls for. It's an example of something that AIMS has implemented that you believe is consistent with what the convention represents. Is that a fair way of putting it?
I couldn't say it better myself.
Yeah.
Yeah, no, that's exactly it.
And, you know, we had a conversation before about how ratification of the convention is probably going to lead to some thinking about these things in other areas. And we had Danielle Wilkinson, who had some experience working as a maritime archaeologist in the UK, particularly with respect to offshore wind farm developments and some similar processes or protocols that are undertaken there and that perhaps will be undertaken in Australia in future as we look at those kinds of projects that both look at how the projects can be done in a sensible way while respecting underwater cultural heritage. So to the extent that you've sort of implemented this and you've had some lived experience of how it works, you know, sometimes traditional owner groups initially being resistant or saying no as a starting point simply because they're not even aware of something that you have been undertaking. But it sounds like as time's gone on, in fact, that kind of partnership has kind of worked, and that when you first started talking, you said that it's obviously that there's a risk if there's a potential for a relevant cultural group to have a problem with a proposed activity. But I guess part of the prior informed consent thing is that when the partnerships exist and you go through this kind of process at an early stage, there's much less put at risk because it's not as if all the planning, it's not as if you're just about to go out to sea in your ship with all your research money and your scientists to start something tomorrow at the last moment you ask. You actually have that kind of partnership in the design and the anticipation of things that you're considering doing.
Yes, however, I think there's an important distinction between the current approvals process, which is widely discussed, you know, environmental and cultural approvals process that any major project undergoes. And the idea is that, you know, you do the things you need to get the approval you need. And that's in many situations, that's exactly how it works, right? There's a very clear goal, get the project up and running and go through this process. To my view, and in my experience, that the free and prior informed consent is different. It's a nuance, but I think it's an important one because there's a partnership level of respect there that tacitly and explicitly recognizes from the outset that we're not here simply to get the approvals to do our project. We're here to open a respectful conversation that should have happened a long time ago, you know, by rights, to have a conversation that's free and open and completely transparent, that recognizes the past and past practices. Like I said, that you know, there's that truth-telling component, which is a critical part of it, certainly in our practice. And so there's a tacit recognition or an explicit recognition right from the beginning that one of the logical and possible outcomes is that you would say, no, not now, you know, maybe not this project or maybe not ever. And so to me, there's a strong difference in tone and approach here that's hard to describe, but when you're in it, you can feel it. Do you see what I mean? Because, for instance, the free and prior informed consent really should happen before the project is really even developed in that sense, right? You don't say, well, I've done all my work, I've done all my engineering, I'm going to put an offshore wind, I was listening to the previous thing, offshore wind turbine farm here. That's the best location for it. And now I'm going to come and try to get your consent to do it. An FPIC ideally would work in a very different way, right? That might be a prospective area where we want to do it, and there might be a number of different prospective areas we want to work in, and we should start engaging in a partnership dialogue with those traditional owners about whether or not they would be interested in advancing this to the next stage of design. Do you see what I mean?
I do, but I mean, I guess what I'm suggesting is that where that becomes embedded in a form of organisational practice, and you have those partnerships and those conversations, then you're not having the scenario you described before, where it's sort of approval oriented, and then
yes.
First Nations engagement, because there isn't a partnership. First Nations engagement is an afterthought, or it's a final threshold or something. The reality is that, because this is what happens in some of these areas, is that people perceive, I think, that you are introducing something that is difficult, obstructive, risky, etc., etc., etc. When while whatever the progress we need to make needs to be real. It can't be lip service, right? You don't want it to be de-risked by being meaningless. But if it's meaningful in an embedded way, then the de-risking occurs because the partnership involves a conversation about this is something we need to do, and here are a range of options, and let's all talk about and have that input at that early stage, which means that the risk that you go down a certain pathway and then it all falls over at the last minute is avoided, because the partnership is there to guide you towards something that works from the outset.
Yeah, exactly. And our lived experience now, we've done it multiple times all over the country, is that in fact, when you go through that process, the word gets around really, really quickly. Especially if there have been a couple of times where somebody said, we don't understand this, so we're not comfortable going ahead now, or we have a dispute with somebody else and you're going to have to wait until, whatever it is, the word gets around really, really quickly throughout the community, nationally, and people know that you're an honest broker and know that you're legitimate and honest about how you're going to approach this. And you're right, and then you start building those relationships, and the word travels fast. So what we found over the last 2-3 years is that our relationships overall and our reputation amongst traditional owner communities, even ones we haven't worked with before, this precedes us, and it makes everything better.
And when this is my last question, I'll throw it to the Deputy Chair, but people might not understand the extent to which AIMS, you do things that are kind of government initiated, or as part of the way that government various departments have to operate. But you do work also that's essentially under contract to private companies. Have you found any particular problem with the method that you've described with respect to that work? Because that's the kind of area where sometimes people are a bit inclined to say, well, that's all very fine if the activity you're doing is already archaeological, or if it's just more generally scientific. If you're talking about the private sector or something that has a commercial aspect to it, there's going to be less appetite for what you're talking about. Have you found that?
Yes, overall. However, I would say that, number one, when we work with commercial entities, 99 times out of 100, it's a partnership. So we're co-investing in a joint project that'll deliver science for the public good. Mm-hmm. And that gives us a partnership position, right? We're not just a contractor tugging the forelock.
No.
And so we basically say, if we want to work together, our policy requires us to do this, and then there's often a discussion, yes, between us and the commercial private sector entity about, well, what does that mean? How does that work? And we take them through it, and at the end of the day, if they don't want to do it, then we just say, okay, well, we're not going to work together.
But you gave the Woodside Perth Canyon example before, so presumably they're happy.
Yeah.
Yeah.
You know, at first they were asking questions and they weren't sure, and they thought it might upset the project schedule and so on, but we have a team of traditional owners who run this for us. So we're hiring really great traditional owner people. We build a whole team. They're the ones that go out and have these conversations with real cultural authority. And in the end, of course, now, with our partners like Woodside and others, I think they really like it. They see the benefits. So we think we're, I guess, bad analogy here, but I think we're trying to lift all boats here. We're trying to, by working with people, we're hoping to also improve their practices in this area, and I think that's happening.
If you keep lifting all boats, there'll be more submerged cultural heritage. I'm going to go to the deputy.
Unfortunately, 3.5 millimeters a year right now. So.
That's right. Yes.
Paul, good to see you.
Nice to see you.
Have you had, with your prior consent model, have you had anything fully stopped? Like, has there been any project that has been completely rejected by the traditional owners, or has there always been either an alternative mood or an alternative option, or is there anything that comes to mind that you can think that has been fully rejected?
Yep. So there was one, and it was up in Gulf of Carpentaria area, and we got a full no.
New project or like your Woodside?
No, it was
example?
a project that we'd done something similar a few years before.
Yeah.
Again, it was legal and we'd done it, and so we'd come with the new process. But of course, if you get a no, you say, well, can we talk about it and can we learn a little bit about why? Because maybe we can find a way, or we're happy, we're flexible. And when we subsequently went through these discussions, it took a while to understand why. Over a year, but there was actually that this particular group was in a dispute with another part of the federal government.
Yep.
And we're federal government, and so they basically said, well, until we resolve this to our satisfaction, we're not going to engage in any sort of other activities with other branches or other agencies, federal agencies. And so what we said was, look, we totally respect that. We have some influence, and we have connections inside the federal system. And if there's anything we can do to help in terms of that particular grievance, and it turns out when we found out the nature of the grievance they actually wanted a new boat for their rangers. And there was an argument about the boat and everything else. I mean, that's probably detail you don't need to know, but just, by way of adding color and detail, over time, we started to work with the traditional owners about how we could help provide them with training and backup so that their rangers could do more science. And by allowing them to do more with the asset in question, it became more viable and more defensible from an investment point of view. And so it took about 2.5 years to memory. I can't remember exactly the amount of time, but it took a while, but eventually we got there.
Yep. And you said you've got a team now of Aboriginal and Torres Strait Islander people. Yep. I'm assuming.
Yes.
How many is in this team?
In that team, there's 6 right now.
They'd be busy.
Yeah, they are. We're trying to hire more.
Yep.
That's one of the issues with anything to do with these kinds of partnerships with traditional owners, as I'm sure you absolutely know, is that they have limited capacity. And so we're also working hard to help on the education side with younger Aboriginal and Torres Strait Islanders to help them gain the skills and the experience to be able to engage and provide this kind of work, provide these kinds of services.
Yeah. No, I get that. You work closely with the Great Barrier Reef Park Authority and Josh there.
Yeah,
I'm
totally.
Have you shared this model with him? And also, I'm assuming that because you've increased your employment capacity specifically for this, you've gone through up to the minister, and the minister's aware of it. Is this something that they are looking to not mandate, but share with other departments a best practice like you have?
Yeah, I mean, for instance, later on next week, I'm going to be giving a talk to the whole of the new Department of Climate Change, Energy, Environment and Water. Mm-hmm. And that's one of the things I'm going to highlight. It's like, what are we doing? And what do we think is best practice that we can share with other groups? Yes, the minister is aware, and her office are very aware of what we're doing. I've spoken about it to her on many occasions. I think she's pretty enthusiastic about it. And in the previous government, for instance, Ken Wyatt was a strong supporter, and he's a great guy. I briefed him maybe 3 or 4 times, a couple times in person here. Mm-hmm. And he was very supportive and very enthusiastic about what we were doing, and that's continuing in the new government. So I think it's great to see that that it's not political. It's everyone knows this is something that needs to happen. And,
fantastic. I agree. And I'll highlight what the chair mentioned before. And nearly all government projects, regardless if it's in the water or on land, have a responsibility to speak to traditional owners. And I have seen it happen at the last minute after everything's been done. There's definitely no walking together or partnership. It's we can do it, we want to do it, we'd like you to support it, and then something happens. So I do think it's a best practice move and a really good initiative, and I'd love for you to share it with everyone else.
Thank you. We're also publishing a couple of peer-reviewed journal papers to get it into the formal scientific and scientific cultural literature. That's, for an organization like ours, a research organization, that's a really powerful way of disseminating best practice as well. So those will be coming in the next few months as well.
And I agree with your opening remarks around the difference between partnering and lip service, and doing things meaningful rather than doing something because you have to, or it's the lip service, like as you described it. So I think this is something that will benefit Aboriginal and Torres Strait Islander people, their culture, in a way that we can walk together.
We hope so. As we put in the final paragraph of our submission, I mean, we recognize, by going through this journey, we recognize how much we still have to do. You know what I mean? It's like anything. Once you start really getting into something and learning about it, the first thing you start realizing is, wow, I don't know anything. And it's exciting, but we're also humble and sobered by the notion of just how much we've learned and how much we still don't know about how to apply this and what more needs to be done, and where and how we can make a difference. And the depths to which the partnerships can go. I think we're just scratching the surface in terms of the impact that we can have. And it's our traditional owner people who now were AIMS employees who are really helping us push that. And I'll give you one quick example, if I may. And it's that part of this whole program inside AIMS is what we call building cultural competence inside our organization. So having our scientists, our non-traditional owner, non-Aboriginal Torres Strait Islander scientists build their competence in terms of understanding the breadth of issues that matter to traditional owners. Because often people just don't quite understand the depths of those things. So you've been to CSIM, I think both. I don't know, Josh, you haven't been, but I know you have, yeah. And I'll give you one story. So we brought, with permission, coral colonies that we collected in the Keppel Islands off Rockhampton to the CSIM so they could spawn, to collect the eggs and sperm and do our experiments about how to help coral reefs survive over the next 20 years of warming waters. When the local traditional owners, who we have a very strong relationship with, the ones that, you know, the people, Bindal people at who are the custodians of our site, heard that the Keppel Island corals were here, they came to CSIM. They asked to come to CSIM to welcome those corals onto their country. Now, it sounds, I mean, ostensibly it could sound a bit dramatic or, you know, whatever, melodramatic, but I was there with them and tell you it was moving. Like it was strange for me from my background, but it was so heartfelt and there were tears in people's eyes. So, you know, that cultural competence is how do we understand what matters to them and making sure that we start making it matter to all of us so we're really doing it all together, you know, in the future. Anyway.
Walking together.
Yeah, like you said, walking together. Good, great words.
And swimming together sometimes. Thank you. I have to do it all the time. Thank you. No, thank you, Paul, and for all at AIMS. I mean, the submission is really interesting, and then you've really added to that and enriched our understanding of it today. So thanks for your attendance. You haven't been asked to provide any additional information that I can remember, but if I've missed something and it's in the transcript, please forward it to the Secretary. It's the witness's responsibility to do that in a timely manner. I don't think we have asked you for anything, so I think that's okay. I would just say, I think, you know, we would be interested if when the peer-reviewed journal articles go to print, please, you know, perhaps refer them to the committee through the Secretariat, just for the interest of committee members, not as evidence to this inquiry. You'll be sent a copy of the transcript of your evidence when it becomes available and have an opportunity to request corrections to transcription errors. But yeah, again, thanks. Nice to see you, and thanks for the time that's gone into this.
No, thank you. Thanks.
Appreciate
Great
it.
to see
Thank
both
you.
of you guys. Thanks for having me.
Yeah, thank you. So committee members, we will suspend now for lunch and resume at 1:40 p.m.
Fantastic.
And I welcome Mr. Duncan Marshall and Mr. David Nutley to give evidence today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
My name is Duncan Anthony Marshall, and I'm appearing as the advocacy convener for CMOS.
Thank you.
My name is David Nutley, and I'm appearing as the expert on underwater cultural heritage for ICMOS.
Very good. Although the committee doesn't require you to give evidence under oath, I should advise you this hearing is a legal proceeding for Parliament and therefore has the same standing as proceedings of the respective houses. That means the giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I thank you both for making time to be with us, and I invite you to make a brief opening statement if you would like, and then we'll proceed to a discussion and questions.
Okay, thank you very much, Chair. Well, I might say just a few things about the organisation Australia ICMOS, and then hand over to David to say a little more by way of the substance and the content of the underwater cultural heritage matters we're considering today. We're here representing Australia ICMOS, a non-governmental professional organisation which deals with all manner of cultural heritage places or sites. And we are part of an international organisation connected very much into the range of international activities under the auspices of UNESCO and otherwise in dealing with our cultural heritage in Australia and overseas. And of course, a very well-known convention which Australia is a signatory to is, of course, the World Heritage Convention. So our interest in this matter is as an important part of the suite of cultural heritage places that exist in the world, but obviously in this case in the maritime environment. And with that brief introduction, I might let David say a few words of introduction.
Very good. Thank you. Over to you, David.
Thank you, Chair. With your permission, I'd like to give a little bit of background of my background, if that's just to give me in context of why I'm here, if that's okay.
Yes.
I'm a previous Vice President of the International Committee on Underwater Cultural Heritage, which is a scientific body of ICOMOS, the International. And I'm also a former President of the Australasian Institute for Maritime Archaeology. My experience with management of underwater cultural heritage stretches around all Australian states and the Northern Territory, and I've also participated in international forums and workshops in over a dozen countries spanning Southeast Asia, Africa, Europe and South America. My training began in Western Australia in 1986 through a combined course run by Curtin University, Western Australian Maritime Museum and University of Western Australia. And I subsequently went on to develop opening exhibitions for the Australian National Maritime Museum in Darling Harbour. And from there I went on to establish the New South Wales Underwater Cultural Heritage Program for the New South Wales Government. And that was a program I continued to develop in partnership with the Commonwealth Underwater Cultural Heritage Program for 20 years. I then spent 2 years in South Australia managing their program before becoming a consultant in private practice as a maritime archaeologist. And in this role, I've worked on projects covering New South Wales, Victoria, Queensland, the Northern Territory and Western Australia. After my initial training in Western Australia, I undertook a master's degree in maritime archaeology at Flinders University in South Australia. My topic explored the potential for places of Aboriginal and Torres Strait Islander significance to survive the process of inundation underwater in offshore, coastal and in inland waters of Australia. My various roles have participated in the interpretation and implementation of the 2001 Convention. And in addition, I was the co-editor of the UNESCO Manual for Activities Directed at Underwater Cultural Heritage guideline, which are guidelines to the annex to the convention. I've also published papers on underwater cultural heritage in national, international books and journals, and I've over 100 archaeological reports covering maritime, Aboriginal and historical archaeological cultural heritage. On that note, there are a number of points that I'd like to raise specifically in regards to the 2001 Convention. For too long, one aspect of Australia's cultural heritage underwater has been overlooked and dismissed, and that's Aboriginal and Torres Strait Islander underwater cultural heritage. It doesn't tend to have appeared in impact assessments associated with things like coastal port riverine developments. And I see ratification as an opportunity to provide a similar level of protection, recognition and community input as already exists for land-based sites. The second point is that in the Asia-Pacific region, ratification creates an opportunity for Australia to underline its respect for countries and cultures in our region. It's an opportunity to promote cooperation in protecting, investigating and managing underwater cultural heritage sites that are important to both countries. And an excellent recent example has been the Australian submarine AE1, which was lost in the waters of Papua New Guinea off Rabaul at the beginning of World War I. The site was discovered in 2017 in a project that was involving governments of New Guinea and Australia, naval cooperation and community input from Papuan eyewitnesses who were eyewitnesses to the event, as well as private and scientific specialists. The outcome is for that project is positive for international cooperation, and it reinforces intergovernmental relationships. It's also an important value to the descendants of Australian and British submariners. There were 35 lost in that incident, and whose ultimate fate was and resting places previously wasn't known. In 2018, the Commonwealth Underwater Cultural Heritage Act came into being and was closely aligned with the 2001 Convention. And this Commonwealth Act provides a model that is currently informing and assisting Australian states and territories to update their own cultural heritage legislation. That's a very important role for the Commonwealth Act. The combination of Commonwealth and state territory alignment is therefore beginning to simplify the process of impact assessment for underwater cultural heritage, underwater development projects. With ratification, Australia can provide further support to our Asia Pacific nations who are considering ratification, or in the case of Micronesia, who, for example, who already ratified in 2018. Underlying this is that the 2018 Underwater Cultural Heritage Act, the Commonwealth Act, is itself a resounding endorsement of the Convention. Point 4 is that international representation is inherent with underwater cultural heritage sites, with many of them at least. Shipwrecks and aircraft, by their very nature and abilities and capacities, they can travel long distances and can have multinational representation in their crews and destinations. And the Convention provides the policies, the ground rules for international researchers who may wish to investigate sites of importance and to their own cultural heritage. For example, shipwrecks and aircraft originating from around the globe and which may be either in Australian waters or Australian registered ships which are in foreign waters. The Convention is consistent with the principles and practices that have been adopted by the Australian Commonwealth Government and the state and territory governments. In addition, the final wording of the Convention itself was approved by the Australian Government and 85 other countries, which was at the time the largest number of nations ever supporting a cultural convention up to that time. Back in 1994, Australia ratified the 1982 UNESCO Convention on the Law of the Sea. This is important because Articles 140 and 303 state that signatories to UNCLOS have an obligation to protect underwater cultural heritage. UNCLOS didn't identify what that mechanism would be, but Article 303 in paragraph 4 recognised that specific regulations for underwater cultural heritage would be needed, and in fact these are what are provided in the 2001 Convention. The Convention was developed to provide ethical, scientific and practical best practice principles and guidance on cooperative national and international management of underwater cultural heritage, and this is now very, very widely accepted internationally as the epitome of best practice. It has very high ethical standards embodied in it. So Australia ECOMOS's recommendation is that it strongly believes that ratification is in Australia's best interest, both internally and in our neighbourhood. And it's important as Australia continues to advance the management of underwater cultural heritage. And on that basis, it therefore urges the TAFE to recommend ratification to the Australian government. Thank you.
Thank you. I appreciate that. Well, look, I'll ask two questions and then hand to the Deputy Chair. Perhaps to you first, David. Yeah, I mean, to what extent do we know that ratification will still require some further work in terms of harmonising Commonwealth and state and territory laws. You've talked about the Underwater Cultural Heritage Act and about the way that we'd like to see, in line with the convention, an approach to marine activity occur, or the approach to marine activity incorporate all due regard for the proper protection and respect of underwater cultural heritage. I'm just invite you, from your point of view and your expert point of view, to what extent do you think that the protocols, the procedures, the requirements that exist at the moment, both how they exist from a regulatory point of view, how they're oversighted, the compliance bits and pieces, all of that, to what kind of standard do you think they are at the moment? Are they where they need to be? Is there further for them to go? And perhaps as part of your answer, if you bring in the element that you talked about, which is First Nations cultural heritage, because almost everyone who's made submissions or given evidence to us has identified the fact that that's an aspect of the way we've looked at heritage, underwater heritage, that is needs to improve. Hasn't been a big enough focus or a sufficiently well understood aspect of what we ought to be considering.
Yes, I think on the matter of where the states and Commonwealth where the states' legislation is progressing, I think there has already been some steps, and I think some states are still in the process. I think they are partly waiting on confirmation of ratification. I mean, the model for the Commonwealth is a good one. It may need some further tweaking, but having that consistency across the states and similar legislation will provide a lot more certainty for developers about what is expected when they are doing some sort of offshore or harbour development which could disturb the seabed. I think that there is some progress being made, but it's a bit hit and miss. And I do think that there is an increased awareness of what's needed, but there's just not the definitive controls for it. I think one of the issues is that, for example, historic shipwrecks for a long time have had protection, automatic protection, and that came about because without automatic protection after a certain time, it relied on sites to be found, to be investigated, and for a case for their protection to be put up. And by then, they had been raided, they had been pulled apart, then all sorts of things could happen to them and were happening to them. Whereas having that automatic protection was important. Now, that has not ever been made the same case for submerged Aboriginal sites. And so it's very easy when something's out of sight, out of mind underwater, to simply say, well, it's not there. But we are finding more and more evidence that it is there.
So the Underwater Cultural Heritage Act as it stands, I mean, because we've had this conversation before, with respect to national heritage terrestrially, it operates on a kind of a nomination and a sort of an opt-in basis. The Western Australian Aboriginal Heritage Act terrestrially actually operated a bit differently. It sort of presumed that things were protected and then obliged development proponents to seek permission to do anything that might impact on that. Are you saying that as it stands now, even with the updated legislation, the Underwater Cultural Heritage Act of 2018, that certain shipwrecks and aeroplane wrecks are automatically protected, but there isn't any automatic protection for Aboriginal cultural heritage?
That's correct. That has to be found first, and then protected and assessed for significance, which just doesn't work. Works terrestrially, it doesn't work underwater.
Is there an obligation under the UCH for any certain kind of defined forms of marine activity that's going to impact the seabed or something like that, for an assessment to occur that determines whether or not there's First Nations underwater cultural heritage present?
Look, I would have to. I'm not a legal person on that. I'd have to get some advice on that. But my understanding, at least, is that recommendations are made and it may be included in requirements, but it's not stated in the Act.
Okay, yeah, because we had someone before talking about, offshore wind, which is a new form of marine development, and the experience that this person had in the United Kingdom. Duncan, I'll just put one question to you and then I'll go to the Deputy Chair. Clearly even though Australia had a significant role in the settlement of the treaty text that was adopted in 2001, it has taken us 22 odd years to get to the point of ratification. And we know that we live in a region where participation in the treaty isn't highly present. How do you see the ratification enabling Australia to be more active internationally and in the region? And sorry, you're on mute, so you just need to demute yourself.
Demute.
Did I say that?
I apologise.
Unmute, sorry.
If I could just make one brief comment, which I'm sure you're aware of, which is that the Commonwealth at the moment is going through a process of developing new Indigenous heritage legislation. I mean, I guess the focus is all on terrestrial heritage, following things like the Juukan Gorge destruction. But Commonwealth officials might be thinking about the maritime environment as well. I mean, there might be a bit of either overlap or gaps emerging potentially between various efforts to ensure protection for maritime Indigenous heritage sites. But just to respond to the question just asked, I mean, I was thinking one answer to that might be to look to the example of the World Heritage Convention. And when Australia became a member of the World Heritage Committee, which it was only a few years ago, I mean, the convention provided Australia with a number of different opportunities to cooperate and to facilitate and to promote heritage activities internationally, but in particular within the region. And I think Australia's participation in the World Heritage Convention and be a member of that committee provided it with a real impetus, a real encouragement to reach out to particularly, I think, the Pacific region, and to provide help, assistance, encouragement, technical advice in a range of ways, which promotes both good intergovernmental relations, but also better heritage outcomes.
Okay, thank you. I'll go to the Deputy Chair.
Thank you, Chair, and thank you both for joining us this afternoon and taking time out of your busy day. I just following on from that question that the Chair just put forward, your colleagues around the world and the people that you speak to, that are in your field and the conferences you attend, I'm guessing they're watching us very carefully and, will be quite happy with the position where we're at. For example, the United States, New Zealand, I think the UK as well, that have not ratified the convention. Do you think the position we are in now and the kind of leadership position, could be potentially follow, or is that discussions you're having?
David might be better to ask that.
I don't know that the discussions are specifically about whether if Australia ratifies it would influence the United States or Great Britain. I think each country has its own specific considerations. By all means, we do talk about the influence Australia has in its own particular neighbourhood, and I think that is where Australia's lead will particularly help countries in our region to not only consider and to ratify, but also to look to Australia for guidance on the implementation of the convention.
Thank you.
That answer?
Thank you. And look, David, I'll come back to you with one more question. I mean, it goes to you mentioned that I think your postgraduate project was a piece of work that tried to consider the kinds of First Nations cultural heritage that would persist in an underwater environment, presumably in circumstances where it was created before that environment was submerged, and that's interesting. I guess there's always a question when you want to undertake a piece of work or you want to implement a new set of principles. There's a question about the capacity, and I'm interested in what you think we might need to consider when it comes to maritime archaeological work, just to ensure that as time goes on, we have the right understanding and expertise, particularly with respect to First Nations cultural heritage.
Yeah, very good question, Chair. It's an area where the underlying principle has to be consultation, community consultation, and in regards to each particular project, because there won't be one size fits all communities, and so there needs to be very clear guidelines about how that consultation occurs. There also needs to be guidelines on what steps, what risk assessment steps need to be, other risk assessment steps need to be undertaken, including remote sensing surveys, historical research, community knowledge, all those sorts of things will be are needed. So the capacity, when you're talking about that, I think it's really a capacity of having guidelines which will allow the Commonwealth and the state authorities to clearly delineate what sort of steps are needed to be taken to consider First Nations underwater cultural heritage.
Okay. Well, thank you both for your attendance, your submissions and your evidence here today. You haven't been asked to provide any additional information that I'm aware of, but if I've forgotten something, obviously anything that we have asked does need to be provided within 7 working days, and it's the witness's responsibility to meet the deadline in a timely manner. I don't think we've asked you for anything additional, but you will in any case be sent a copy of the transcript of your evidence when it becomes available, and have an opportunity to request corrections if there are any transcription errors. But thanks again for sharing your experience and your expertise with us.
Thank you.
Thank you.
Go straight into it. Next one's on the line.
Okay, I believe we have Mr. Alec Coles with us. Yes, I can see you, Alec.
Yes.
Welcome to this J. Scott hearing on the Convention on Underwater Cultural Heritage. For the Hansard record, could you just state your full name and the capacity in which you are appearing before the committee?
Yes, so I'm Alec Coles. I'm the CEO of the Western Australian Museum, and in that capacity, I am the delegate for the Commonwealth in WA for the Underwater Cultural Heritage Act, and obviously also administering the State Maritime Archaeology Act. Can I also say, beside me, or just out of screen, I think, is my head of maritime archaeology, Karali Suter, who will advise me if I need any technical information.
Sure. Thank you. And although the committee doesn't require you to give the evidence today under oath, I should advise you that the hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses, which means the giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. So just to get us started, I invite you to make an opening statement or some brief opening remarks, and then we'll have more of a general discussion.
Sure. Thank you, Chair. The Western Australian Museum, in many ways, can claim primacy in this area. The Maritime Archaeology Act, State Act of 1973, I believe, was the first in the world to protect underwater cultural heritage and indeed land-based cultural heritage related to historic shipwrecks, and led to the subsequent creation of the Historic Shipwrecks Act, which was then rolled into the Underwater Cultural Heritage Act. We, I believe, have probably the largest capacity of any state working in this area, not surprisingly, because we have a very long coastline. At the moment, we estimate something like 1,600 historic vessels, apart from anything else, along our coastline. And it's a very important part of our work. We are absolutely, as in our written submission, supportive of ratification of the convention for a number of reasons, which I'm sure will develop. But as much as anything, it's reaffirming Australia's lead in this area, because it has led in this area over a long period of time. It seems somewhat incongruous that we have failed to ratify this previously, given that there's 71 countries ahead of us. But there's also a real opportunity to lead by example for the Indian Ocean region. To my knowledge, only Cambodia and Madagascar in our sort of immediate area have actually ratified this. And yet the Indian Ocean is such an important area going way back into antiquity in terms of international trade. And needless to say, therefore, the underwater cultural heritage is extensive around it. And I think that is a really important message to send. One of the other areas that our museum has been very active in is in training colleagues internationally in the protection, administration, and management of underwater cultural heritage. And I think, again, the signing of this convention would actually place Australia in a strong position to influence that activity worldwide. And I think there's huge potential, actually, in order to look at establishing an international training centre here in this area, because we have so much capacity.
Yeah, thank you. I mean, it's. I think all of that's well said, and certainly in the material that we've been provided in our consideration of this treaty action, it's notable that WA was well and truly ahead of the curve. I think first by amending the then Museums Act, and then with a sort of standalone piece of legislation and various things since that time. In the submission that's been provided, there is a statement that to the effect that if Australia proceeds with ratification, the instrument of ratification should note that state jurisdictions like Western Australia require further time to review and amend their own legislation in this area. When the department was with us earlier, we got the sort of the impression that that it was, of course, contemplated that there would be this further process of updating and harmonising. Do you want to just speak to that suggestion in the submission that you think it should sort of be noted that there's further time? Is that because you think that there's a significant bit of work that needs to be done on that front?
I think it should be noted. I think we've been fairly upfront about this because, in fact, we need to update this state legislation to harmonise with the Commonwealth Act, actually, notwithstanding the convention. And that process is well underway now. We are at a point of consultation prior to obviously developing the drafting, but we have strong support from our minister to progress this, and I'm hoping that it's well advanced now. I think one of the benefits of the ratification is that it does bring another layer of harmonisation. I know there are still some elements, so instance, the definition of I suppose the temporal definition, 100 years or 75 years, there are always going to be those inconsistencies. But the more closely we could harmonise under that convention, certainly the better, and that is our intention with the redrafting of the Act.
Okay. We had some conversation just before about the way that the convention and then any respective legislation will work in practice when it comes to development proposals that could potentially impact on maritime submarine cultural heritage. What's your view about how that, well, either how it works now and how it might work better in future? Because there's always the two different kinds of approach you can have with national heritage. Terrestrially, things that are of national heritage significance need to be sort of nominated, and then they're part of the register, and there's 130 of them or something presently. But until that occurs, national heritage isn't ascribed to something. The Western Australia, the previous bit of Aboriginal cultural heritage legislation took almost the reverse approach and sort of said everything is potentially protected and you need to get a permit before you do anything, and the permit process allows us to consider whether there's heritage there. What's your sort of sense of, well, how does it work now if someone goes to propose a bit of offshore oil and gas or a cable or a dredging operation or something? What's the process now with respect to underwater cultural heritage, and what do you think is the best approach in future?
Well, again, it's fair to say, because of, I suppose, the Venn diagram of the overlap of different acts, it depends where it is, because there are elements that would be covered by our state act that aren't actually covered by our own act. I think the example you give, particularly around First Peoples, Aboriginal Torres Strait Islander material, which only, I guess, relatively recently, I mean, it's for instance, wonderful to see the nomination of Murujuga for World Heritage status today, and remembering that there's considerable underwater cultural heritage relating to First Peoples that's been discovered off there. So I think the ratification, again, of the convention would provide stronger automatic protection for that. I'm a great believer that, where possible, and this is, you mentioned the Aboriginal Cultural Heritage Act, that automatic protection is the way we should go. It is inconsistent across states, and indeed sometimes in legislations where you've got heritage acts, you've got acts related specifically to Aboriginal cultural heritage, you've got maritime heritage, and so we really need to look at that. And again, I think the convention sets down important principles to which we should adhere in that respect. In terms of development, again, Western Australia, as we know, is a place of considerable offshore development, and for that reason alone, I believe it's particularly important that this is implemented, and certainly my sense is there's never been any resistance from major developers to this, largely wanting to do the right thing actually, but sometimes confused by the multiplicity of legislation and the overlaps.
No, I think that's a point well made. Obviously, when it comes to underwater cultural heritage, it's not just about proper protection and conservation of that heritage, but also in appropriate ways of making that heritage accessible and being able to share it and benefit from it. And Western Australia has some very good examples. The Shipwreck Museum down in Fremantle is one of them, and that's an instance too where you get the application of principles that include, in many cases, leaving something where it is, but in some cases removing it and preserving it properly, but making it available. Do you think that there is potential for the expertise we have in Australia around those kinds of methods, both identifying cultural heritage where it is in the ocean, but in some cases removing it, preserving it, and making it available? Do you think that we can do more potentially in future with other nations to help them take a similar approach? And are you aware, for instance, the kinds of things that we're able to go to at the Shipwreck Museum or the Maritime Museum in Freo and the Maritime Museum in Geraldton and similar things around the nation? Does that exist in our region? Are there some equivalents in places like Indonesia or other Pacific nations?
Well, certainly around the world there are, equivalences, and particularly in our region. If you go to Singapore, for instance, if you mentioned Indonesia. But I think if I can go back to the crux of the question, obviously the removal of material has a number of risks to it. So firstly, quite often it's preserved because of the environmental conditions in which it's in, and maybe in anoxic conditions, it may be buried, whatever. And then of course there is the cost of removal. So quite often the presumption is for in situ preservation, and that's laid out in the convention as well. And it's certainly something that my team here at the Museum is quite experienced in, has done a lot of work on. Now, obviously, as you say, if you visit the Shipwreck Museum in Fremantle, you'll see a lot of underwater cultural heritage that has been removed. And so where that is, I guess, accessible, possibly at risk, it is important to remove it. In terms of interpretation, it's wonderful to be able to use that material. And again, we in Australia have a good deal of expertise in how to go about that. But we also have, considerable experience in digital interpretation. And so one I'm sure you're familiar with, Chair, is the, bringing things to much more contemporary. The Sydney Cormorant, where, HMS Sydney and Cormorant sites were nominated under the Old Historic Shipwrecks Act, even though they're outside the Australian waters, because that provision exists for sovereign material. And the digital interpretation of that material that you would never seek to move has been quite extraordinary. So it very much depends on circumstance and the work that is possible, fundable, but you also have to think of the site itself. But certainly, a major, I guess, mission of this museum, and I'm sure, our equivalents across Australia and across the world, is exactly as you say, to promote understanding. And I think that brings in another element of, the importance of this. Signing this, not only, and again, I was witness to the latter part of the last submission. We know that major nations around the world are not yet signatories. US, UK were two that were mentioned specifically. I do think there is a leadership role here. I'm not suggesting for a minute that Australia signing it will drag the others to the table, but I think it sends an important message. But it also provides an opportunity to really foreground the importance of this kind of heritage. Where we've seen damage, or indeed in some cases destruction, it's I would suggest more usually through ignorance rather than mischievousness. And so the more opportunity we have to promote the importance of this, the better. And I think this provides an ideal opportunity for that.
Yeah, well, thank you. And again, appreciate you making time both through the submission and your attendance here today. I don't think we've asked you to provide any additional information, but if it has been mentioned, I've forgotten it. It does need to be provided within 7 working days. I don't think that that's the case. You'll be sent a copy of the transcript of your evidence when it becomes available, and have an opportunity to request corrections to transcription errors. But yeah, again, thank you for the work that you've done and for sharing some of those thoughts and your long experience and expertise with us today.
Pleasure. Thank you very much.
Thank you. Committee members, we're just going to suspend for 5 minutes while we see if we can get the next witness. Public hearing of the J-Scott. I think we're broadcasting again. That's excellent. And I will welcome AJ Moore to give evidence today. For the Hansard record, will you please state your full name and the capacity in which you appear before the committee?
Hi, my full name's Amy June Moore. I'm known as AJ Moore. I'm here in the capacity of representing the Sydney Project, which is a recreational, scientific and technical dive group.
Cool. The committee doesn't require you to give evidence under oath, but I need to advise you that the hearing is a legal proceeding to Parliament, therefore has the same standing as proceedings to the respective houses, and that means the giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. So thanks for making a submission and being with us today. I invite you to make some brief opening remarks if you'd like, and then we'll have a bit more of a conversation.
Sure. Well, thanks for having me. So I've just been watching all day, sort of fangirling over the calibre of the other speakers and seeing them in person rather than just names on my bookshelf has been pretty amazing. So I'm here a little awed and a little inspired, I guess. We've been sort of hearing from these academic giants and people on the front line of government and legal legislation all day, whereas I'm coming from the complete opposite end of the spectrum, just the civilian recreational diver who works with a group of other like-minded divers with an interest in the sea, basically.
Okay, well, I mean, yeah, look, we're probably closer to you than we are to some of the other experts that appear before us, and that's the nature of the work that we do. And to be honest, I mean, the value of these kinds of processes is that we get as wide a range of people and perspectives to help inform our consideration and to be part of parliamentary committee work and decision making. So nobody should ever apologise for taking the time to be part of it. We're grateful to you, and it's exactly what we like to see more of. So perhaps just for our benefit, talk a little bit about the Sydney Project and the people that you do your diving and your amateur maritime archaeological investigations with. I think that's really interesting.
You're very generous. We're not actually maritime or archaeology or maritime thought leaders as such. Most of our members come from completely different fields. We've got doctors and veterinary people and media people and utilities people, trades, geeks like me. So we're not necessarily sort of working in museums or in government departments. So we very much have just normal civilian day jobs as such, and it just, I think self-proclaimed rust addict is a term that goes around. So the interest has generally been from diving. Most of us started just as recreational divers, typical scuba divers, cylinders, air, that kind of stuff. But then we were sort of finding that the limits of our ambition and imagination was exceeding the limits of being able to dive on oxygen. So we switched to technical diving, rebreathers, that sort of stuff. So we kind of can push the boundaries on what's typically recreational diving in the 30-metre capacity down to the 100-metre capacity. So we've been able to explore some areas of the seabed that aren't necessarily typically available recreationally, but that has allowed us to explore some shipwrecks that we certainly would not otherwise have seen.
Yeah, but I mean, yeah, so while, as you say, none of the people in the group are archaeologists or academics, but part of what connects you and the activities you undertake is nevertheless an interest in underwater cultural heritage. Some of the diving you do, at least, is not for the sake of looking at fish or something. It's looking at cultural or historical artefacts or features of the submarine world that are part of that area.
That watery world, yeah, fish can get in the way when you're trying to do photogrammetry. So it is definitely more interested in the artifacts and the shipwrecks. The marine life is cool as well, don't get me wrong. I worked on the Niggly Reef for a while on part of the United Nations heritage site over there. So fish life is cool, but they've got to live somewhere, and that's what the rust is for. So.
So does some of the stuff that you do, does it ever interact with that more professional world? So if you go as a group and you look at some underwater cultural heritage and you do take photographs or other kinds of, there's some other kinds of evidential gathering, I assume that some of that might be informed before you undertake a dive by trying to reach an understanding of the significance of what it is that you're looking at and all of that. So you do a little bit of historical and archaeological pre-reading, but to the extent that when you go and do a dive, you come away with some sort of evidence, some data. Do you ever go and share that back with a state-based, like a museum or something that has an interest in the cultural heritage material?
Yeah, we've actually been really, really lucky about that. So we've been really open in our communication with government about what we're finding, what the condition of the wreck is, how we found it, if we got it from marks from fishermen or if we're just returning to a site for the second or third time afterwards. Because of the sites that we're diving on are quite deep, they're not necessarily every weekend kind of dives. So they kind of can be very spaced apart, especially during COVID. Not a lot really happened. So there was time for some research on that side of things. I think one of the main changes in regards to how we've been able to communicate with government is it's been an increasingly open door. 20 years ago, we might not have been having this conversation. There was a lot of mistrust, I think, between government and recreational groups and government. I think there was a lot of, they won't let us dive, or they'll shut the site if we tell them. And I think a lot of those old style attitudes have sort of fallen away to the point that now we're advocating for these changes. So when the convention came up, it was a case of, here's a clear cut, get rid of the ambiguity, here are the guidelines that really advocated for more open communication, not just with our group, but with other groups as well, in regards to how we can find information, knowledge share, get our findings to government for the benefit of museums and everybody else who doesn't necessarily want to dive to 100 metres themselves.
No, quite. We be careful. They'll start sending you, mission instructions. So the Sydney project, I guess you could be described as sort of citizen marine archaeologists, in the way that you have citizen science groups that go out and take an interest in wetlands or something, and then they might gather some data. They're probably not scientists, they could be teachers or whatever. It seems to me that you exist in a slightly similar category. Are there other organisations or groups that like yours that you're aware of? Is there a sort of a recognition of the fact that around Australia there are other groups like you? Do you have some convention where you all get together?
Dr. Viduka that was on earlier is very much at the forefront of that citizen science movement, which has been rising in all sorts of industries, not just in diving. I think we've got one that monitors the frogs down the road from here, so there is a lot of this citizen science movement. But But again, it's been very unstructured for a long time until things like this convention come in to sort of, be the framework that can hold it all together and to provide a bit of structure around how are we going to do this. The thing about the Sydney project and our eclectic mix of members is that they are all very passionate in their own field. The love of diving is often the only thing that they agree on. Don't get started talking about, beer or football preferences. It's just united in this interest in preserving underwater cultural heritage and diving on wrecks. So I think in a way, the way that attitude has been changing over the years to become more receptive to working more collaboratively with government, with museums, with other dive groups, with other dive companies overseas. It's kind of just gone on this continuum of getting more and more enthusiastic and more receptive to some sort of framework. So again, when the convention came up, it was like, here it is, sort of here's the path.
And has the group ever gone on a sort of an international mission? I mean, is that something that people in groups like this contemplate? Like you hear of an incredible thing that you might go and see in the territorial waters of another country, and you make that a sort of a project?
Yeah, some of our members supported Tim Smith with the AE2 over in Turkey. So quite a few of them were pretty active in the South China Sea, investigating some of those wrecks. I don't think you can hold back a diver if there's a chance of diving on an interesting wreck. So,
Right, Deputy Chair.
Yep. 100 metres. That's quite deep. It's further than I would like to go. We spoke with the Department this morning of Climate Change, Energy and Environment and Water, and I asked a question that you kind of touched on, and just then around when will you, if they find a new site, so whether you found it or they find it, does it get blocked off for a bit from the public? How do they communicate that? And then what's the process after? Have you anywhere in your dives had this occur? And if so, did it work and was it communicated correctly and well? Or was there touch points that probably need to be fixed?
There's always room for improvement. Generally, we've been very quick with our marks. I saw David Nutley on here not too long ago from when we did some work with him previously in New South Wales. So we've been pretty as open as we know. A lot of the times when we're receiving marks, there are some fishermen. We've caught our net on this mark every time we've been there. So it can take a while to sort of be, okay, there might be something there, but it could just be a rock.
Yeah.
So we can get a suspicion of a site for a while until you finally get the chance to get down there, run a sounder over it, run your magnetometers, get a feeling of what's actually there before you send actual people down. Deco is a long time when it's that deep. So you kind of want to be sure that there's something there. So we've been really open about communicating, we think there might be something here, but we're not sure yet. And then as soon as we've known that there's been something there, to be really open about, we've found something, but we don't know what it is. Do you guys know what it is?
Are you talking about to the department, or is that who you're communicating to? Yep.
Yeah.
Okay. And that's a positive. You're working collaboratively with the department, and then from we think something's there to don't dive there anymore for a while, or go back to diving away. Has that happened in any of the times that you've had to contact the department?
I think in our case, if they were going to go and investigate it, they'd probably need us to do that anyway. So I think maybe the depths that we're working at are possibly more collaborative than if they were in the shallows. But I think the attitude is that if things needed to be shut down for proper survey, then that would be the right thing to do. So
what depths do you work at? Could you remind me again? What depths do you work at?
Up to 100 metres, 120 metres, I think was one of the deeper ones.
How long does it take to get down to 120 metres?
Not very long to get down.
A little bit slower coming back up.
About 7 hours coming up, yeah.
7 hours. I'm glad that you do this. And
What he means is he's glad that you do it instead of
me.
us.
Well, I appreciate your answer, and I am enthused of the collaborative nature that you can work with the department.
Thank you. The attitude, sorry.
No, you go.
I think, the attitude very much is on the preservation of the heritage. I think as a dive community has matured a lot over the last couple of years in particular. I mean, the Sydney project, this is our 20th year in operation. And when I was old enough to start diving and started listening to some of the conversations, there was a lot of reluctance to work collaboratively with government and even other dive groups. There was a lot of, oh, don't tell anyone about that wreck, that's mine, or that's mine. And then you'd hear these horrible stories of the guys that had come over from the UK talking about, oh, they can salvage things and sell them for X amount of money. And that whole attitude, I think, has had a real paradigm shift in Australia over the last little bit. The emphasis, and I think the general consensus from our community group, at least, is very much on the preservation of the sites, keeping them open, but keeping them safe for the sites themselves as well as the divers. The attitude of taking stuff off wrecks, I think I haven't heard that for years and years now. I mean, I, for one, and everybody that I know in the community would far rather see the archaeology on the wreck and not in someone's garage.
Yeah, well, look, I think that's a really worthy sentiment, and it's good to hear from your direct experience that sort of cultural norm is being established. I think we've sort of probably seen that more broadly in the way that people interact with the environment over the last 10 or 20 or 30 years. The whole kind of take only pictures, leave only footsteps sort of mentality. I certainly, when I was a kid, if I went somewhere, I used to often think about taking a stone or rock or something just to remind me of wherever it is, and I just don't tend to do that anymore. Not that it necessarily matters, but I think it just goes to a broader ethos of respecting and leaving things as they are, because they are like that, and then other people can enjoy it. So it's nice to hear that seems to be the case in the diving community. Perhaps just the final question. To what's your sense of you're at a fairly high spec end of the underwater wreck diving community. Like, I know that in my electorate there's a wreck called the Omeo wreck. It's literally sort of 5 metres offshore, and there's a big sort of set of stairs that allows you down into the shallow water. When the tide's out, you can pretty much sort of walk out and be next to it with your swimming goggles. That's about as much of the sort of the diving wreck experience as I probably need to have. You're at a different level, but what's your sense of the current state and perhaps the potential of sort of diving heritage-based tourism for a country like Australia?
Well, we are an island, so I wouldn't necessarily recommend technical diving be a recreational hobby. However, with the technology that we've been looking at lately, and everybody's advocacy and easy adoption of digital technologies, photogrammetry and 3D modelling of shipwrecks, it's not necessarily a future thing, it's already here, So being able to get accurate surveys of three-dimensional wrecks in their in-situ position, in their as-is current state now, means that revisiting over the years, you can just build up those layers of what's missing, what's changed, and you can really kind of get the further story, like the rest of the life cycle of the ship beyond just its time above water. The ship's journey doesn't finish when it hits the seabed. The journey, the story continues as it morphs into becoming an artificial reef, as it messes up the seabed around it, as it changes the topography or the bathymetry of the water, like the sand bend around it. So it sort of becomes part of the next phase of the journey and the story, things that are happening around it. So you don't necessarily need to be there in person to experience that if there's things like digital technologies where it makes it a bit more accessible to people who don't dive at all, really.
Yeah, no, that's a good point. I mean, I think the potential of that technology combined with VR, virtual reality kind of stuff, 3D goggles, people will be able to have incredible experiences. Alec Colson from the museum was talking about the Sydney and the Cormorant before, which was is a good example. Well, AJ, thank you for your attendance here today, for taking the time to both make the submission and then appear before the committee. We haven't asked you to provide any additional information, but it's just part of these procedural remarks that I remind people that if for some reason they need to provide it to us within 7 working days. That hasn't been the case for you. You will be sent a copy of the transcript of your evidence when it becomes available and have an opportunity to request correction to transcription errors. But again, thanks and happy and safe diving.
Thank you, and likewise.
My diving will be done in the bathtub.
Okay, committee members, we'll just suspend for a couple of minutes to see where we're at in terms of the next witness. We're otherwise going to have a... Okay, we'll now resume this public hearing of the Joint Standing Committee on Treaties, and I welcome Graham Henderson to give evidence today. For the Hansard record...
Thank you.
Yeah, that's good to see you. For the Hansard record, will you please state your full name and the capacity in which you appear before the committee?
Graham John Henderson, and I appear in a personal capacity.
Thank you, Graham. The committee doesn't require you to give evidence under oath, but I should advise you that the hearing is a legal proceeding of the Parliament, therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I invite you to make a brief opening statement, and then we can have a conversation.
This area of legislation has been a major part of my life, going back to a time when I was 60 years ago, when I was a 16-year-old, and went diving with my father on his boat and a couple of others, including my brother and another diving mate, and I happened to find a shipwreck totally by accident, and found elephant tusks and bricks and cannon on the seabed, and that started a whole massive different issues, which were incredibly exciting, I found. And so once the first silver coins were found, it all changed from being terrific fun and very interesting adventures into heritage, and it turned into all sorts of problems. And for me at 16, having a person say that he'd let off an explosion in the water with me, which he did, was a very substantial part of my life in terms of what should I do at that point. So I didn't go in the water again up there until I had joined the museum and went there as part of the archaeological team. But I went on from there to do a degree in history at UWA, then joined the museum, and then became director of the Australian Maritime Museum. And so that was a major part of my life, and things went from there.
Yeah, well, look, Graham, I've been fortunate enough to meet you before, and I've got a copy of one of your books, and I acknowledge the involvement that you've had over a very long time, and the contribution that you've made has been really significant. I'm sure that for you, to see Australia at the point of ratification, that you take some satisfaction in that, and you'd welcome it, as you've said in your submission. From your perspective and your considerable expertise, what kinds of things will be enabled by us ratifying the convention? How will it enable Australia to do more, both in our own maritime environment, but more internationally when it comes to maritime cultural heritage?
I think it's a wonderful opportunity for Australia to really lead the world. We got going with our national legislation, had problems with that, but I think we came out on top, and that was a shining example for other countries. But that was covering just Australian waters. Then, of course, the convention developed essentially a network across the world's oceans, which meant that in the underwater cultural material area, we could do something that, in a sense, you could never do on land. We were able to cover the whole world underwater, and it was an incredibly impressive thing, I think, for Australia to lead the world in this way and do so by having this cooperation between different nations. It requires cooperation between different. By that, we can. It is really needing to be protected.
Maybe you can help us understand one thing. It is the Deputy Chair has rightly pointed out that the convention hasn't been ratified yet by ourselves, but nor has it been ratified by New Zealand, the UK, and the United States, as far as we can tell. Do you have any insight into why, those countries, together with ourselves, have been a bit slow to the ratification party?
Suggestions. I'm not familiar with the exact details of the reasons why it couldn't be ratified. There are suggestions of there being submarines not able to cross particular paths that they need to cross. My vague understanding is that that sort of issue has been resolved. So I don't see issues to do with defence causing that. I know that in some countries there was a very much incorporated group of people who were feeling that this was endangering freedom of the seas, that it was stopping legal salvage of things, and was therefore an interruption of people's right to do whatever they wanted to do, essentially, commercially. These various things I vaguely understood had been overcome. The question of the defence issues, I'm told informally that that's no longer a terrible fear.
Okay. When it comes to the risk or the threat to cultural heritage that occurs through the activities of treasure hunters, what's your sense of how that is combated internationally today, and to what extent do we contribute to that effort? What are the ways in which a country like Australia, presumably in partnership with other countries, try to keep an eye on that, whether it's through tracking the sale of certain items or whether it's through maritime surveillance? What's your sense of how that kind of enforcement and compliance actually occurs?
Well, I'm not in a position to know the details of that sort of thing because I'm not involved with those sorts of groups of people. But certainly the idea of having a situation where both countries, two countries, join together and look at how to combat destruction of that environment. I guess the relationship we have with the Dutch is a very good one. The ANCODS agreement, whereby there's to Australia and the Netherlands to look after the Dutch shipwrecks off the West Australian coast. And that has been very successful. And indeed, my understanding is that part of the logic of the convention comes from the ANCODS agreement. The ANCODS agreement, of course, meant that the Dutch were quite happy for Australia to then take that historical material and put it into museums here. But there was an agreement with the Dutch whereby they had legal rights to the material coming down from the Dutch East India Company going to the government. The Dutch East India Company doesn't exist anymore, but of course the Dutch government does. And so there was there's the similar sort of logic there, whereby two countries come together to ensure that the underwater cultural heritage is dealt with in a modern way.
Mm. You make a point in your submission that we haven't previously touched upon, which is just around the way that various different maritime museums operate. So I take it from what you've submitted that in the past, different museums or collecting organisations in different countries just went about things in a variety of ways rather than there being some accepted best practice. And you've had some involvement previously as the chairman of the International Congress of Maritime Museums, and I gather that some of that work went to trying to make sure that best practice standards in museum collecting and operation were adopted. Does some of the work that you've done in the past, I mean, does the convention relate to that? Does the convention touch upon some of those kinds of things?
Well, the convention obviously has an influence on the collecting practices of museums around the world, and so that's very important. Museums, if museums behave in a manner which is responsible, then it's going to be very good for the underwater cultural heritage. If they behave in a manner which is not responsible, then it's going to destroy the underwater cultural heritage, and that was the general debate that we had. It was over the Titanic wreck, because the captured the world imagination, and the way some of the people they weren't the initial finders, but they came in fairly soon after that, and they came in with this heavy grab equipment and so forth, which was destroying large portions of the wreck very quickly before world eyes, and the world attention was on that wreck, but there was no sense of looking after the wreck in any way. It was just smash and grab, and fortunately, with that subcommittee, we got the attention of the museums around the world, and came to a very good conclusion along the lines that the museums would take very much strong note of the what might be called the ethical guidelines that were being laid down.
You make a point in your submission too about the benefits that are associated with tourism, and I guess the way that underwater cultural heritage can be shared and experienced, and that might be sort of, in an Australian context, it could be domestic tourism, people being interested in that kind of material as they travel from one part of Australia to another. Obviously, it would also be a matter of interest for international tourists. Do you have a sense of, of how significant that is already? I know that it's part of life in WA, and I expect in all around the country there are different aspects of that. Do you think that we make enough of that potential at the moment, or whether there are things that we could do to enhance that, make it a bigger part of the sort of the destination attractiveness of a place like Australia?
I think that it can be emphasised more in Australia, but wherever you look, there's obviously opportunities. If you think about Australia's territories, Norfolk Island, it has its Maritime Museum now, which is part of the tourist attraction there. If you look at the Cocos, Keeling and Christmas Island territories, I think there's really interesting things that could be done there in terms of utilising the shipwrecks. They have lots and lots of shipwrecks there on Cocos, for instance, which are in wonderfully easy. It's a paradise diving there. Lovely underwater, fish everywhere, lovely tropical fish and so forth. But there are the wrecks in shallow, very clear, safe water as well. You can see all sorts of fish live. It's an absolutely glorious occasion to have a dive and see what's going on underwater, and get more involved with what the heritage of those places is.
Well, you sold me. I'll try and see if I can have that experience at some point. Is there anything else that you want to share with us from your perspective about the significance of the potential ratification, which is under contemplation by government? We're inquiring into it. Is there anything else that you'd like to share with us about the significance of the convention and its ratification?
I think it's particularly important for Australia as having initiated this whole process. It was a wonderful journey going through that that process of being involved with getting the one piece of legislation after another, and then going on to the convention itself and the various ethical ideas that came forward together with that legislation. But Australia can, I think, progress its relationship with all the countries in the Pacific and the Indian Ocean in a very positive way by getting this ratified and becoming a leader again. Countries within both those oceans must think, why has Australia not ratified if it's something that we all should be ratifying? So when a number of us tell other colleagues in other countries you ought to get it ratified, the obvious question that must be remaining in their minds is, why hasn't Australia? I think it's something which can be very good diplomatically between Australia and all these countries in our neighbouring environment.
Yeah, no, that's well said. All right, well, Graham, thank you for your attendance here today and for your submission. It's really nice having you part of this. We haven't asked you to provide any additional information, so I don't need to let you know about the timeline for that. You will be sent a copy of the transcript of your evidence when it becomes available, and have the opportunity to request corrections if there are any transcription errors. But thanks for your work and the application of your expertise in this area over a long period of time.
I'm delighted to have had this opportunity, and I wish you well with the results of it all.
Yeah, thank you. All right, we're moving on to the next witness, Professor Craig Forrest. Are you with us, Professor Forrest? Professor Forrest, we can't hear you. You might just need to unmute. No, I'm afraid we're just not getting the audio at the moment, Professor Forrest. Just give us a second and we'll see if we can do something about that. Committee members, I think we'll just suspend for a couple of minutes while we try and resolve this IT issue. Just to stop the broadcast. And if we stop the broadcast. Switched on. All right, we'll resume this hearing of the Joint Standing Committee on Treaties for our inquiry into the Convention on Underwater Cultural Heritage, and I now welcome Professor Craig Forrest. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Craig Forrest. I'm the Professor and Director of the Marine and Shipping Law Unit at the T.C. Burns School of Law, University of Queensland.
Excellent. The committee doesn't require you to give your evidence today under oath, but I need to advise you that the hearing is a legal proceeding. The Parliament, therefore, has the same standing as proceedings of the respective houses. Giving a false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. So thanks for being with us. I invite you to make an opening statement or some remarks if you'd like, and then we'll proceed to a bit more of a general discussion.
Okay, well, thank you very much, and thank you for this opportunity. Yes, to contextualise my submission, it's worth noting that I was a member of the South African delegation to UNESCO while these negotiations were taking place, and was actively involved in negotiations from 1997 through to 2001. Also been active with UNESCO, assisting UNESCO in its regional intergovernmental meetings that UNESCO has to introduce countries to not just this convention, but its other cultural heritage conventions. In fact, the first one I was involved in was 2000 in Solomon Islands, where we were involved in a regional meeting about the Underwater Cultural Heritage Convention in this part of the world. And I think it's telling, since that meeting, none of the participants have become state parties. I've also been involved in a number of similar meetings in other parts of the world, in the Caribbean, Cambodia, Indonesia, and more recently been a consultant with UNESCO looking at various countries' legal gap analysis, national interest analysis in terms of ratification of this convention. 2021, we did that for Solomon Islands, 2022 for Marshall Islands, and we're about to work on a consultancy national interest analysis for Fiji. So I guess that contextualises some of my background. It's also worth noting that I am a sports diver. I'm a member of the Brisbane BZAC, that our president, Tom Poston, has made a submission to this inquiry. And we're actively engaged in REX and working REX in very close cooperation with the Queensland. In terms of my submission, I've had the benefit of watching these proceedings since Dr. Viduka introduced them earlier on, so I'm not going to go into detail, but I want to make a couple of points in relation to my submission. First of all, I hope I'm still clear.
Yes, you're sort of breaking up just a little bit, but there's probably not much you can do about that, so I think we're getting most of it.
Possibly turning off the video.
It might be worth, I know it's better if we can all see one another, but perhaps if you turn your video off, sometimes that just means that your bandwidth is being directed to the audio capacity and we can just hear you more clearly.
Right, I'll turn the video off and we'll see how we go. Right, so in terms of my submission, a lot has been said during these deliberations this morning about the nature of the underwater cultural heritage and particularly its application to Aboriginal and Torres Strait Islander heritage. I think it's worth noting, of course, that the convention was designed to protect underwater cultural heritage beyond the territorial sea of a state. After all, every state has the jurisdictional capacity to protect its own underwater cultural heritage. And so while the convention enforces that and assists that, it wasn't the intent of the convention to do that originally, although the convention morphed into one where those international standards that Graham was responsible and his committee were responsible for creating has applied to all underwater cultural heritage. I guess the real value of ratification is that it gives that international endorsement to the underwater cultural heritage that Australia wants to protect. It enables Australia to protect that knowing that it's underpinned by an international framework. And it allows Australia to explain to those who are stakeholders with that heritage that whatever steps Australia is going to undertake is consistent with international practice. So I think that although Australia has the jurisdiction to protect underwater cultural heritage in certain waters, ratification of the convention gives that some kind of international framework. It's also worth noting, I think one of the previous submissions reflected this, the Law of the Sea Convention, to which Australia is a party, required us to protect underwater cultural heritage. And this convention is merely an extension of that existing international obligation. Again, a number of speakers have also talked to the point about international engagement. I won't talk to that too much, other than to reflect on the fact that ratification will enable Australia to participate in not just the meeting of state parties, but also the other organs that are created by that convention, including the scientific and technical advisory body. And I think it's important that Australia be a party to that. After all, it is that body which advances not just the knowledge of underwater cultural heritage, but also the practice of underwater cultural heritage in those states that are party. So that participation, I think, in that international arena is an important one for Australia, for a range of reasons that a number of the speakers have spoken to. including tourism, the universities that teach here, etc. I guess the one issue that I'm going to talk a little bit about, which has not been discussed much in these deliberations, is the extent to which the Convention enables Australia to protect the underwater cultural heritage beyond the territorial sea. And after all, that was the intent of the Convention. And I think it's clear that international law is somewhat equivocal on the rights of a state in relation to its flag vessels, particularly its sovereign vessels like warships, etc. The principle of sovereign immunity and the continued ownership of those ships, I think, is not yet customary international law such that we can rely on that to make a claim when that heritage lies in somebody else's waters. And I think that's evident in the experience of HMA as well, and the difficulties Australia had in protecting that right. What the Convention does is create a cooperative regime, but also one that enables Australia to assert some kind of a cultural interest in underwater cultural heritage in other jurisdictions. The Act does that, and the Convention will simply enable us to do that. So the Convention, I think, is a cooperative regime that enables us not just to protect underwater cultural heritage in our waters, but to give us mechanisms to protect underwater cultural heritage in everybody else's waters. I guess my last point, by way of a very long introduction, and I apologise for that, is something which I didn't include in my submission, but it relates to the fact that Article 18 of the Convention requires states to return underwater cultural heritage that's come into its territory where that underwater cultural heritage was recovered in a manner inconsistent with the Convention. What that means, though, is that if another country is a party to the Convention and Australia is a party to the Convention, any underwater cultural heritage that enters that country can be returned to Australia. I think that's important in recognising the fact that enforcement of illicit excavations or salvage of underwater cultural heritage on the continental shelf or in the beyond the jurisdiction of the state is very difficult to manage. The only way to police that kind of activity is where you land that heritage rather when activity is taking place. And you cannot do that effectively unless you're a party to this convention. After all, it's the convention which really gives effect to that. Again, those are just my opening statements. I'm happy to discuss any of those points. I might just turn my video on quickly and see how we go with it.
Yeah, sure. And thank you, Professor Forrest, and you certainly don't apologise for the introduction. They were all good points, and it's helpful for us when, in addition to people making the time to appear, they also make the time to listen to the proceedings, because it then tends to mean that as people come on, they fill in the gaps. And so we appreciate that. You make a very good point about the purpose of the convention with respect to the high seas, or the areas that are outside of national maritime jurisdictions. I guess it'd be interesting for us to know, like, to the extent, we're only about to ratify the convention now, but there are other nations that have ratified the convention. Are you able to sort of speak to examples of where participants to the convention have used the convention, or the convention has been the basis for other nations to, assert their cultural heritage in material that is in international waters, effectively in a way that wouldn't have been possible without it?
In terms of the mechanism by which the convention creates a kind of cooperative scheme where you have underwater cultural heritage on somebody's continental shelf, given that the convention only came into force in 2009, and if you look at the countries that have become party to the convention, there hasn't been a great many opportunities to do that. Perhaps the best example, perhaps the only example of an actual cooperative regime is the one that's currently underway in the Mediterranean, where you have a number of countries, but particularly Morocco, I believe it is, and Italy, where those countries have engaged in a cooperative regime, one part of it led by Italy, one part of it led by, I believe, Morocco, on an expedition in waters which obviously wreck that flows into both of those countries' jurisdiction. So there is that example of where UNESCO has facilitated an actual cooperative regime for underwater cultural heritage. That heritage, in a sense, is a shared heritage, though, in that very, very old stuff that could have come from any one of those jurisdictions. So there is that one example of an actual cooperative regime. I believe that's the only one that's actually sort of giving effect to that convention. Partly that is, I think, because it's the only place in the world where you have all the relevant countries surrounding that water being party to the convention. Australia, that would require us and our near neighbours all to be party to the convention for the convention structure to actually operate. I think that's part of the point made by many of the participants here, that we need to lead those countries to ratification.
Yes. So just to take you back to some of the things you said in the early part of your remarks, you said that you participated in some sort of get together in Solomon Islands, and then you said it's sort of telling that none of the participants, presuming including us, have yet ratified. I mean, we're considering ratification, but why did you say it's telling? In what sense?
Well, in the sense that without Australia leading that, I don't think any of those countries are going to ratify that convention. And partly that's a capacity building issue. Without sort of a more specific international regime, I think a lot of those countries are simply not engaging in the issue. So my experience with the Solomon Islands, for example, and of course the Solomon Islands is a particularly important jurisdiction given that we have HMAS Canberra lying in Solomon waters, casualty of the Second World War. So we do have heritage in their waters. But the Solomon Islands is engaged in that issue, but is not going to move on that issue until Australia becomes a party.
Okay.
Because they do rely on Australia very heavily for expertise, etc. And it's also the case that once you become a party to that convention, it enables you to get assistance not just from other state parties, but from UNESCO. The reality, I think, and I say this without knowing this, what I believe is that a lot of those countries know that the assistance is likely to come from Australia. So while they are entitled to assistance from other state parties or funding what little there is from UNESCO, the reality is that is likely to be channeled through Australia.
Okay.
Once Australia becomes a state party, that's much more likely then to channel through.
Yeah, and I might have got this wrong, but were you suggesting before that you have been engaged in undertaking some preparatory legal work that might be related to the consideration of other nations in our region around their participation, their ratification of the convention?
In a limited sense. So what UNESCO, through its Pacific office, does is enable countries in the Pacific to consider ratification. My job would be to look at their legislation and trying to identify to what extent that legislation would need amendment if they were to become a state party. So really it's the same process that Australia undertook in adopting the Underwater Cultural Heritage Act, to make sure that there's legislation in place prior to ratification so that you can give effect to your international obligations on ratification. So that's the task I have been doing for UNESCO for the two jurisdictions that I mentioned, Solomons and Marshall Islands, and then Fiji. And so part of that is simply to look at the legislation, identify the gaps that exist in that legislation, and then with other colleagues to identify whether there is in fact a national interest for that country in ratifying that convention.
We've asked a few people. I mean, obviously the better protection and more appropriate and respectful dealing with underwater cultural heritage can be advanced by the convention to the extent that the state parties then observe the principles and sort of action the obligations within the convention. One of the sort of the threats that exists to underwater cultural heritage is through the looting and the treasure hunting type of activity. Does the convention really offer anything particularly on that front as far as assisting in the detection and the combating of that kind of behaviour? And I mean, do you have a sense of how well that occurs at the moment? We've got evidence that says, the more the technology changes, the more accessible it is. Well, the sort of the looting and the treasure hunting becomes more possible for a wider range of people. You just don't, the technology
Absolutely.
becomes cheaper and better for finding things and then potentially picking it up off the seabed. But I'm interested in your sense, if you have one, as to how it happens and who combats it, and do we participate in that and all those things?
Well, I think it's again, technology has allowed various entities to come into contact with underwater cultural heritage, either intentionally because that's what they're looking for, or unintentionally because they exploration for mining interests. Of course, the technology also increases in terms of surveillance, whatever kind of surveillance. It may be drone surveillance, it may be satellite surveillance, etc. But the reality, I think, still is that it's very difficult to identify instances where there is unregulated access to the underwater cultural heritage. And again, I think where the convention is important is not where that activity is taking place, but where the material is then landed. Because if the material is landed in a jurisdiction that is party to the convention, it has an obligation to return it. And I don't think that's dissimilar to the Texing, for example, where the Texing was a Chinese junk recovered in possibly Indonesian waters. A lot of that material was channeled through Australia on its way to Europe for sale. Australia managed to seize only a small part of that, but that was based on the Protection of Movable Cultural Heritage Act. This would expand the basis upon which Australia could do that. The inverse, of course, is that any underwater cultural heritage, recovered in the South China Sea, and then has to be landed somewhere around the South China Sea. If it is landed in a country that is a party to the convention, and Australia is a party to the convention, it gives rise to an obligation to return it. And I think that's perhaps one of the important parts of the convention, that the convention can obviously give Australia some capacity to take control over underwater cultural heritage on the continental shelf. So in an emergency, the convention allows it to do that. But it's going to be very difficult to actually police that. To give effect to that, the other countries to be parties to that convention. And that's only possible if you give effect to the obligation to return. Fortunately, what that does is that you've already had a looted site, but at least you get the objects back. But if somebody knows that the objects are going to be returned after the looting, there's a disincentive to then engage in those sites in any way. So, a couple of examples of that will mean that there's going to be less activity, I suspect, because those who recover it know that wherever they land it, it may have to be returned.
Yeah.
And of course, there's also, the other thing that a number of the other participants have mentioned is that Australia was at one time the exporter of the salvors who were engaged in these activities, and the Texing is an example. What the convention, of course, does then is it captures those Australians who want to recover underwater cultural heritage and bring it into Australia. Because once you bring it back into Australia, Australia then has an obligation to return that to a jurisdiction where it came from. So it also pleases Australians who are going to go out into the South China Sea, recover material, and then bring that back to Australia.
Yeah, no, that's a very good point. All right. Well, look, is there anything else that you think we should know from your perspective as we consider the proposal to ratify the convention? I mean, you've covered a lot of things, and some of them that we haven't heard before. But is there anything else that you want to leave us with?
Well, I guess there are just two comments I'd make, and I guess in a response to some of the discussions made earlier. One of the things that's really important here is the protection of cultural heritage, and we touched on this. Some examples, but a lot of the cultural heritage that we are talking about are what people call maritime graves. And I think Dr. Viduka quite rightly pointed out that these are not actually graves. They aren't protected as the last remains of anyone. There is no international concept of a maritime grave. And therefore, human remains are only treated as archaeological remains. That's the reality. The only way to really give effect to that, though, is through this convention, because at the very least, this convention regards human remains as part of the archaeological assemblage. And it provides at least some protection for those human remains. And that's going to become more and more important as we get closer and closer to the beginning of the Second World War and all those losses. Fortunately, it now applies to First World War wrecks, and we do have examples of those in Australia as well. So that's one point I want to make. And then lastly, the question of the United States, the United Kingdom, and New Zealand came up. I wanted to touch on those very quickly. The United Kingdom had a number of objections to the convention in 2001 and therefore abstained from voting. There's been a number of reports produced that really debunked those objections, one of which was that there's some inconsistency between the convention and the Law of the Sea Convention. I just don't think that holds water anymore. I think a number of countries that had similar objections have overcome those objections and become a state party like France. So I don't think the United Kingdom really has any principled objection to the convention that it can rely on. And I would not be surprised if the United Kingdom eventually became a party to this convention. The United States, of course, is a completely separate jurisdiction, and I won't comment on that jurisdiction too much, other than to say that my understanding of their constitutional structure makes it difficult to give effect to the convention. But it's also my understanding that the US federal government applies the annex of the convention to all activities that take place on federal lands. So the convention is partly implemented by the United States through the adoption of the annex as best practice for the federal government and for some state governments. So there is a partial adoption, at least, of the convention's principles and good practice in the United States. I'm not sure about New Zealand, but again, one of the participants this morning said, like many of our other neighbours, they're just waiting for us.
Yep. No, look, and that's a fair point. I mean, and it is interesting. I mean, the comment you make about the United States. I mean, clearly, we have had the convention in mind as we have done some things in recent years, including the new piece of legislation, the Underwater Cultural Heritage Act. So it's not as if, I mean, while I understand the frustration people have expressed about the delay in our own ratification, it's not as if we've turned a blind eye to the convention, what it means and what it requires in all of the intervening period. But nevertheless, it seems like it's good to have reached the point where ratification is now being advanced. Yeah, and thank you. Thanks for being our last witness as part of this public hearing, for your attendance here today, the submission and the evidence you've just given us. We haven't asked you to provide any additional information. No. But we will send you a copy of the transcript of your evidence when it becomes available, and you'll have an opportunity to request corrections to any transcription errors. But yeah, again, thanks for your work, your expertise, and for sharing it with us.
Thank you for the opportunity.
Okay, committee members, I will declare this public hearing closed.